Good evening. I'm Sidney James, Chairman of the Board of the public television outlet in Washington, of which Impact is a division. I'm one of hundreds of interested citizens, laymen and laywomen, who volunteer to serve on the governing boards of public television stations throughout the country. In the first 37 days of this historic event, public television brought you more than 200 hours of gavel-to-gavel coverage, an average of 5½ hours a night. And now we are making a fresh commitment. We will continue our same basic format, a brief introduction, the unabridged proceedings from beginning to end, with interruptions only for station identification, and finally, some commentary. Public television's decision to carry these hearings from gavel to gavel is based on a demonstrated interest in our doing so. We have received hundreds of thousands of letters and phone calls here in Washington and at public television stations across the country. The message was very clear. You thanked us for bringing the proceedings to you in full in the evening hours when you were at home. Many of you sent in checks in gratitude. We thank you again for that. You told us you had learned a great deal about your government and about how valuable it was to eyewitness an event of such great moment, and you told us to please continue. Thus, the decision to do so was one in which all of us interested in public television participated, including you and the public television station you are now tuned to. And now, let's go to today's hearings.
I want to emphasize that at the time of the Watergate operation, I considered my participation as a duty to my country. I thought it was an unwise operation, but I viewed it as lawful. I hope the court will sustain my view. But whatever that outcome, I deeply regret that I had any part in this affair. I think it was an unfortunate use of executive power, and I am sorry that I did not have the wisdom to withdraw.
In the Senate of the United States, a resolution to establish a select committee of the Senate to conduct an investigation and study of the extent, if any, to which illegal, improper, or unethical activities were engaged in by any persons, acting individually or in combination with others, in the presidential election of 1972, or any campaign, canvass, or other activity related to it. From Washington, NPAC brings you gavel-to-gavel videotape coverage of today's hearings by the Senate Select Committee on Presidential Campaign Activities. Here is NPAC correspondent Jim Lehrer.
Good evening, and welcome back to Watergate. E. Howard Hunt, the Watergate saga's #1 super spy, was the lead-off witness today as the Senate Watergate Committee put its controversial show back on America's center stage. The 55-year-old Hunt, using the spy terminology he learned firsthand as a CIA agent for 21 years, added a lot of fascinating inside stuff detail to what the committee and everyone else already knew about the Watergate and Ellsberg break-ins, general intelligence gathering for the Nixon campaign, and other operations connected with his part-time work as a White House and re-election campaign operative. Hunt makes it clear that his close relationship with former White House aide Charles Colson has deteriorated, noting for the first time publicly that he believes Colson had prior knowledge of the overall Liddy intelligence plan, but not necessarily the specifics, including the Watergate break-in. Hunt, a quiet, meticulous man, also recited the personal tragedies which have befallen him since Watergate, including the death of his wife in a plane crash. All of this happened today, of course, and it occurred in the context of this day, rather than when the committee broke for its summer recess August 7th. There has been a flurry of activity since then, particularly at the White House. It began with a presidential television address and was followed by 2 televised news conferences. The president continued to maintain he was not aware of any Watergate activities. He also chided Congress for not getting more done and sent them a new agenda as a sort of mini State of the Union message. With us tonight is Hugh Sidey, who observes the presidency for Time magazine. Mr. Sidey, it looks as if Mr. Nixon has been on the offensive thus far. Has it worked, do you think?
It seems to me that what we have observed here is White House theater more than commitment to national leadership. Perhaps we'll be proven wrong in the days ahead. Perhaps there is something more. But once again, We have all the stage props, the press conferences, the meetings, the right things said and done. But indeed, we have in the country a frightening number of forces that are loosed, unfettered. Inflation, the price of food, the energy crisis, and yet it seems to me that they've devoted their time to the Watergate problem, and it's still the same problem, still the same format. And indeed, we lack a clear voice, a clear person in which the country has confidence. The last Gallup poll shows that Mr. Nixon's popularity or the confidence in him has declined.
All right, sir. Mr. Nixon, of course, has also been standing firm on those White House tapes. On August 9th, the Senate committee went to court for an order directing Mr. Nixon to release them. 3 weeks later, Judge Sirica ruled on a similar subpoena from Special Prosecutor Cox that the judge should listen to the tapes in his chambers. On September 6th, the White House appealed the decision. A week later, the appeals court suggested that Prosecutor Cox and the White House work out a compromise, but that also was turned down. In addition, two Watergate figures, Jeb Magruder and Donald Segretti, have pleaded guilty in federal court and are now awaiting sentencing. And 4 former White House staff members, John Ehrlichman, Eagle Krogh, David Young, and Gordon Liddy, have been indicted in Los Angeles in connection with a break-in at the office of Dr. Daniel Ellsberg, psychiatrist. Our other guest tonight is Jack Murphy of the Georgetown University Law Center. Mr. Murphy, it seems as if the courts have taken over some aspects of the Watergate scandal, as Mr. Nixon has requested. So legally, where are we now?
Well, we have fairly sharply drawn the issue of power of the president to withhold information versus the power of the courts to administer the criminal justice system, and the power of the United States Senate to implement its legislative mandate. It's a critical constitutional question, largely unresolved, of course, by the precedents. We don't know how it's going to come out. But I think it's clear that, as with other constitutional litigation in the past, the decision will be on a practical basis. The courts will examine this matter and decide whether or not, in these circumstances, the presidency can survive intrusion into the privacy of his office for purposes such as the smooth administration of justice or for the purpose of the Senate in implementing its mandate. Now, how it will come out is hard to predict, but that's the way the issue will be drawn.
All right. Back to today now with Peter Kay on Capitol Hill, setting the scene for E. Howard Hunt and the Senate committee in light of the developments that occurred over the summer recess.
Watergate Round 2 on its first day was something of an anticlimax. 2 months ago, E. Howard Hunt's testimony would have been fascinating, but at this point in time, it seems to have been overshadowed by other events. The indictment of John Ehrlichman and others in the Ellsberg break-in case, the continuing battle over those White House tapes, and of course a separate scandal involving Vice President Spiro Agnew. Now, in the light of all this, there was a feeling in the caucus room today that Hunt's testimony about the Watergate and Ellsberg break-ins and other White House horrors seems to be out of date. Now, you will hear new details about possible involvement of former White House Special Counsel Charles Colson, testimony buttressed by memos and by transcripts of phone conversations. And one of those memos contained a friends list to go with that famous White House enemies list. The friends list consisted of sympathetic newsmen, columnists such as William F. Buckley, William White, Ralph D. Toledano, Jenkins Lloyd Jones, and Stuart and Joseph Alsop, newsmen Clark Molinoff, Kais Beach, and Willard Edwards, news executive Neil Freeman, and ABC's Bill Gill. Now, this was intriguing but hardly sensational. And even details of the famous Howard Hughes caper in Las Vegas failed to stir the committee, the press, or the galleries. Now, maybe tomorrow, if they could substitute Howard Hughes for Howard Hunt, I guess not. Jim?
All right, Peter and I will be back to talk further with Mr. Sidey and Mr. Murphy at the close of the broadcast. And as we've been doing each night that we replay these hearings, here is an hour-by-hour rundown of the testimony. In the first hour, E. Howard Hunt says that he believed he was acting on authority that was within the power of the president when he took part in the Watergate break-in. Hunt also says it was White House aide Charles Colson who asked him to fabricate cables linking the Kennedy administration to the assassination of President Diem. In hour number 2, Hunt tells how Gordon Liddy recruited him, saying that Attorney General Mitchell wanted an intelligence operation. Hunt also testifies that he recruited a spy called a penetration agent to work inside the Muskie campaign. The spy, who was to supply campaign schedules and contributor lists, was later transferred to the McGovern offices. In the third hour, Hunt admits telling a CRP attorney he had performed seamy activities for the White House, but denied that it was a threat to get money to provide for his family. Also in that hour, Hunt says he told Gordon Liddy, "Let's junk it," when McCord discovered the tape had been removed from the basement doors in the Watergate building. He says his advice to scrub the operation was ignored. In the fourth hour, Hunt is pressed further about Charles Colson's knowledge of the Gemstone operation. Hunt draws the line between awareness and active participation. Also in that hour, Hunt says that when he sought disguises and photographic equipment from the CIA, no one there objected. Now to Senator Ervin in the caucus room of the old Senate office building.
Mr. Hunt, the counsel will call the first witness.
Mr. E. Howard Hunt.
Mr. Hunt, will you stand up and raise your right hand? Do you swear that the evidence which you shall give to the Senate Select Committee on Presidential Campaign Activities shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Now let the record show that Mr. Hunt is testifying under an order granting him a use immunity. Counsel, proceed with the interrogation of the witness.
Mr. Hunt, are you accompanied by counsel?
I am.
Mr. Counsel, would you please identify yourself for the record?
My name is Sidney S. Sachs. I'm a lawyer, member of the Bar of the District of Columbia, and I'm accompanied by my partner, Mr. Robert M. Scott, and my law clerk who's been helping in this case, Mr. Henry Goldman.
Mr. Hunt, do you have a statement which you wish to read to the committee?
I do.
Would you read it, please?
Mr. Chairman, members of the committee, my name is E. Howard Hunt. I am here today to answer questions bearing on your current investigation.
Mr. Hunt, I think it would be better if you took the microphone and brought it closer, or more directed it closer to your mouth.
I have been informed that it is permissible for me to make a preliminary statement, and I want to take advantage of that opportunity. I will describe my personal background, my relationship to the Watergate entry, and events which have befallen me since that day. I was born in 1918 at Hamburg, New York. My father was a lawyer and judge, my mother a pianist and housewife. I was educated in the public schools of Florida and New York, and in 1940 graduated from Brown University. 6 weeks later, I volunteered to serve in the armed forces. While a destroyer officer on the North Atlantic convoy run before Pearl Harbor, I was injured and medically discharged. Later, I volunteered and became an Air Force intelligence officer. In 1944, I volunteered for the Office of Strategic Services, the forerunner of the CIA, and was sent to China, where I was engaged in partisan warfare until the end of World War II. In 1949, I joined the Central Intelligence Agency, from which I retired on May 1st, 1970, having earned 2 commendations for outstanding contributions to operations ordered by the National Security Council. During the 21 years I spent with the CIA, I was engaged in intelligence, covert action, and counterintelligence operations. I was trained in the techniques of physical and electronic surveillance, photography, document forgery, and surreptitious entries into guarded premises for photography and installation of electronic devices. I participated in and had the responsibility for a number of such entries, and I had knowledge of many more. To put it unmistakably, I was an intelligence officer, a spy for the government of the United States. There have been occasions, as one might expect, when covert operations by the United States or other nations have been exposed. Such episodes have not been uncommon. When such mishaps have occurred, it has been universally the practice for the operation to be disavowed and covered up. Usually this has been done by official intervention with law enforcement authorities. In addition, the employing governments have paid legal defense fees. Salaries and family living expenses have been continued. Former CIA Director Helms has testified before this committee in regard to some aspects of this practice. After retiring from CIA, I was employed by a firm whose officials maintained a relationship with the CIA. Some months after I joined the firm, I was approached by Charles W. Colson, special counsel to the President, to become a consultant to the Executive Office of the President. Mr. Colson told me the White House had need for the kind of intelligence background which he knew I possessed. This was the basic reason for my employment, which I understood at the time was approved by John D. Ehrlichman, and now understand was approved also by H.R. Haldeman, both assistants to the President of the United States. From the time I began working at the White House until June 17, 1972, the day of the second Watergate entry, I engaged in essentially the same kind of work as I had performed for CIA. I became a member of the Special Investigations Unit, later known as the Plumbers, which the President had created to undertake specific national security tasks for which the traditional investigative agencies were deemed by the President to be inadequate. In this connection, I was involved in tracing leaks of highly classified information. These investigations led to an entry by the Plumbers into the office of Dr. Lewis Fielding, Dr. Daniel Ellsberg's psychiatrist. The entry was authorized by Mr. Egil Krogh, deputy to John Ehrlichman. It was considered necessary because of the belief that Dr. Ellsberg or his associates were providing classified information to the Soviet Union. The operation was carried out with my assistance under the direction of G. Gordon Liddy, a lawyer, former FBI agent, and member of the Plumbers Unit. The Fielding entry occurred in September 1971. In late November, I was told by Mr. Liddy that Attorney General John N. Mitchell proposed the establishment of a large-scale intelligence and counterintelligence program with Mr. Liddy as its chief. Mr. Liddy and I designed a budget for categories of activities to be carried out in this program, which came to be known as Gemstone. It was my understanding that the program had been approved by Messrs. Jeb Stuart Magruder, a recent White House aide, and John W. Dean III, counsel to the President. Later, I learned that Charles W. Colson, special counsel to the President, had approved it too. In April 1972, Mr. Liddy told me that we would be undertaking the Watergate operation as part of the Gemstone program. He said he had information, the source of which I understood to be a government agency, that the Cuban government was supplying funds to the Democratic Party campaign. To investigate this report, a surreptitious entry of Democratic National Headquarters at the Watergate was made on May 27, 1972, and a second entry on June 17th. The second entry was accomplished by a group, two of whose members had been among those who accomplished the Fielding operation. I was indicted for my part in the Watergate entry. Following indictment, and prior to my guilty plea, the court ordered the government to produce all material taken from my White House safe and other evidence. Some material was produced, but significant material was withheld or destroyed. Because the government had withheld evidence, I knew there was no chance of proving my defenses. In addition, my wife had been killed in an accident in December, and I was deeply depressed and anxious to devote myself as quickly as possible to the welfare of my children. Accordingly, I had no alternative but to concede that I was wrong, and so I pleaded guilty, hoping for merciful treatment by the court. Instead, on March 23rd of this year, I was provisionally sentenced to prison for more than 30 years. The court stated that my cooperation with the grand jury and with this committee would be considered in determining my final sentence. Since being sentenced, I have been questioned under oath on more than 25 occasions, often for many hours, sometimes for an entire day. I have answered thousands of questions by innumerable investigators, prosecutors, grand jurors, and staff members of this committee. I am informed that such intensive and repeated interrogation is a most extraordinary procedure and of dubious legality. Even so, urged by the court to cooperate fully, I have not contested the procedure. In fact, I have answered all questions, even those which involved confidential communications between my attorneys and myself. After my plea, I learned of obstruction of justice by government officials. I learned of willful destruction and withholding of evidence, and perjury and subornation of perjury before the Watergate grand jury. This official misconduct deprived me of evidence which would have supported my position that A, my participation in the Watergate was an activity authorized within the power of the President of the United States, and B, if my participation was not so authorized, I justifiably believe that it was. Within the past few days, therefore, I have asked the court to permit me to withdraw my plea of guilty and to dismiss the proceedings against me. I believe the charges should be dismissed because, based on revelations made public since my plea, evidence is now available to prove that my participation was not unlawful, and because, to quote Judge Byrne when he dismissed charges in the Ellsberg case, quote, the totality of the circumstances of this case offend a sense of justice. The bizarre events have incurably infected the prosecution of this case, unquote. It has been alleged that I demanded clemency and money for my family and for those who helped in the Watergate entry. I did not ask for clemency. Mr. Liddy assured me that, in accordance with established practice in such cases, funds would be made available. I did seek such funds, but I made no threats. Now I find myself confined under a sentence which may keep me in prison for the rest of my life. I have been incarcerated for 6 months. For a time I was in solitary confinement. I have been physically attacked and robbed in jail. I have suffered a stroke. I have been transferred from place to place, manacled and chained hand and foot. I am isolated from my 4 motherless children. The funds provided me and others who participated in the break-in have long since been exhausted. I am faced with an enormous financial burden in defending myself against criminal charges and numerous civil suits. Beyond all this, I am crushed by the failure of my government to protect me and my family, as in the past it has always done for its clandestine agents. In conclusion, I want to emphasize that at the time of the Watergate operation, I considered my participation as a duty to my country. I thought it was an unwise operation, but I viewed it as lawful. I hope the court will sustain my view. But whatever that outcome, I deeply regret that I had any part in this affair. I think it was an unfortunate use of executive power, and I am sorry that I did not have the wisdom to withdraw. At the same time, I cannot escape feeling that the country I have served for my entire life, and which directed me to carry out the Watergate entry, is punishing me for doing the very things it trained and directed me to do. Mr. Chairman, honorable members of the committee, I thank you for your attention and your patience. I will now undertake to answer your questions to the best of my ability.
Mr. Hunt, your statement has, I think, put sufficiently in the record introductory material concerning your background and your career and your present status under the sentence of Judge Sirica, and therefore I will not go into those questions or repeat that. In the early part of 1971, Mr. Hunt, did you discuss with Mr. Colson the possibility of your obtaining a position at the White House?
I did.
Did you have a telephone conversation with Mr. Colson, and who initiated that telephone conversation?
I had numerous telephone conversations with Mr. Colson, Mr. Dash. I appreciate your being a little more specific.
Yes. On July 2nd, 1971, or July 1st, actually, did you receive a telephone call from Mr. Colson?
I did.
Let me show you what purports to be a transcript of that conversation. Would you please look at it?
I have examined the purported transcript, Mr. Dash.
Does that purport to be or reflect the conversation you had with Mr. Colson?
It does.
Yes. Now, in that conversation with Mr. Colson, does Mr. Colson question you concerning your viewpoints and attitudes concerning the Pentagon leaked papers and Mr. Ellsberg?
Yes.
And would you look at page 2 and the last line, and would you read that for the committee?
Colson's question?
Yes.
Quote, let me ask you this, Howard, this question. Do you think with the right resources employed that this thing could be turned into a major public case against Ellsberg and co-conspirators? Question mark, unquote.
Yes, and how did you respond to that on the top of the next page?
My response was as follows. Yes, I do, but you've established a qualification here that I don't know whether it can be met.
All right, would you continue to read the next few lines? Yes. You should have copies of that, and I understand we're checking now that full set of all of these exhibits were handed out, and some of the people next to me have indicated that that particular transcript is not there.
Are we making arrangements to...
Yes, they're being run off now. They should be a part of a set that was given to every member of the committee and yourself, Mr. Thompson.
Could we delay momentarily until we get copies? I've had requests that will be able to follow along.
All right, would you... well, I can continue the questioning without reference to that transcript, Mr. Thompson.
All right.
Did you understand, by the way, Mr. Hunt, that from that conversation, Mr. Colson was exploring the idea with you of a major effort to discredit Mr. Ellsberg in the press?
Yes.
Now, did Mr. Colson eventually offer you a position in the White House?
He did.
And I think you've indicated in your statement that he referred to specific qualifications. Can you repeat that? What did he indicate to you your qualifications led you to that particular position? What qualifications?
The fact that I had an investigative background of some years, and also that I had been involved in political action operations.
Now, were you interviewed by anyone besides Mr. Colson?
Yes.
Who was that?
Mr. John D. Ehrlichman.
Whose directions, Mr. Hunt, did you work when you took this position? Under whose directions?
Under Mr. Colson's direction.
Now, can you describe your initial assignment under Mr. Colson?
Mr. Colson instructed me to become the White House resident expert on the origins of the Vietnam War. At the same time, I had a collateral responsibility for determining certain leaks of highly classified information, which included the leaks of the Pentagon papers.
Now, is it true, Mr. Hunt, that from the beginning of your employment, Mr. Colson asked you to collect what could be called derogatory information about Daniel Ellsberg?
Yes.
Now, what was to be done with this information when it was collected?
My assumption was that it would be made available by Mr. Colson or someone in his confidence to selected members of the media.
Did you, by the way, early in your employment, collect a list of certain media representatives who might be interested in such material?
I did.
Now, how did you develop the information on Mr. Ellsberg following the assignment you received from Mr. Colson?
It was developed through an intensive study of reports furnished by the Federal Bureau of Investigation.
Were there any other materials that you used?
There were certainly overt materials.
I didn't hear your answer, Mr.
There were overt materials.
What do you mean by overt materials?
Materials published in the press.
Now,
let me, to be more responsive, Mr. Dash, I have a feeling I've left something hanging here, which I don't want to do. The same unit, the Special Investigations Unit that was receiving information on a frequent basis from the Federal Bureau of Investigation, was also receiving reports from other government agencies, such as the Department of Defense, the Department of State, National Security Agency, the Immigration and Naturalization Service, and so on. So that as part of my reply to your question, I would include those government agencies as sources of information on Dr. Ellsberg.
All right, now, do you recall Mr. Colson asking you to interview Colonel Lucien Conin?
I do.
Who is Colonel Conin, or who was he at the time you interviewed him?
At the time I interviewed Colonel Conin, he had just retired from the Army, I believe, and was in the process of retiring from the Central Intelligence Agency, or had retired therefrom. He and I had trained together in the Office of Strategic Services for service in the Far East, and in fact we had shipped out to China together and worked in China together during World War II. I had seen him infrequently during the intervening years, but we had maintained a friendly relationship.
Do you recall when this interview took place, your initial interview with Mr. Conin?
It was on or about the 8th of July of 1971.
Excuse me, Mr. Dash. Could we confer for just a moment?
Yes.
Yes, I wonder if that's possible, yes.
Mr. Chairman, is it possible that the photographers who are here right just a few feet from us and clicking their cameras could be asked to remove themselves to some more distant place so that there would be less distraction to Mr. Hunt? There are, as you can see, Your Honor, maybe a dozen people here who are doing their jobs undoubtedly, but it is a little distracting.
Mr. Hunt, do they distract you?
They do, Mr. Chairman.
Well, I'll have to ask the photographers to sort of get over to the side somewhere where they won't distract Mr. Hunt. Because I have to always, up to this committee, to receive Mr. Hunt's testimony.
Thank you, Mr. Chairman, and I apologize to the photographers involved.
All right, now, Mr. Hunt, ready to proceed?
Yes, sir.
Yes. Could you just briefly describe what occurred? Did you initially interview Colonel Conin?
I did.
And did you follow that interview by a telephone conversation with Colonel Conin?
On the following day.
What were the circumstances that led you to make a telephone call after the interview?
During my initial interview with Colonel Conin on the 8th of July, it developed that a portion of the tape recording of that conversation was inaudible. Accordingly, Mr. Colson suggested that I telephone him and attempt to reconstruct the inaudible portion of the recorded conversation of the prior day. Mr. Colson at the same time was on another extension, introduced himself to Colonel Conin as, quote, Fred Charles, unquote, and took a minor part in the conversation that ensued between Colonel Conin and myself.
Do you have any explanation as to
excuse me just a moment.
Mr. Chairman, I'm sorry.
Can't see Mr. Hunt, or rather, why Mr. Hunt can't see them. And I'm going to have to ask him to desist. I hate to do that, but I want the witness not to be have his attention distracted.
Can you explain to the committee, Mr. Hunt, why Mr. Colson wanted to be a part of that conversation and why he chose a pseudonym as Fred Charles?
Well, you've asked me two questions, Mr. Dash.
Answer the first one. Why did he want to be a part of that conversation?
He wanted to be a part of the conversation so that he could interpose himself to ask a specific question, whatever specific questions might occur to him as relevant to the subject of our conversation in our prior interview, and in effect to hear for himself at first hand Colonel Coneen's reply.
And why did he use the name Fred Charles?
To avoid being connected in Colonel Coneen's mind with the White House.
Do you know what the purpose of Mr. Colson's asking you to interview Colonel Coneen was?
Yes.
Could you explain that?
I would have to go back a number of years and make it a matter of record that Colonel Coneen had worked for the Central Intelligence Agency in Vietnam, I would say almost uninterruptedly since 1954. Colonel Coneen had a high degree of intimacy with senior officials of the several governments that had held power in South Vietnam. He was also a military officer. He spoke French. He spoke Vietnamese to some extent. He was intimately familiar, too, and I believe that this gets to the crux of your question, with the events leading up to the coup that resulted ultimately in the deaths of Premier Zim and his brother-in-law.
And was the interview supposed to be directed towards that coup and the underlying causes of that coup, which led to the assassination of Premier Diem?
It was.
Do you have, Mr. Hunt, a transcript of that telephone conversation, I think, which the committee has provided you during the executive session?
I have it somewhere. I do.
Now, would it be also fair to say that one of the purposes of the conversation was to get information from Colonel Coneen which might be derogatory against Dr. Ellsberg?
One of the purposes, yes, sir.
As a matter of fact, would you turn to page 4? And you see that at toward the third paragraph from the top of page 4, referring to H, which I take it to be yourself, Mr. Hunt. And you say that after a reference to Mr. Van, that I'm getting very curious about that guy and what his connections with Ellsberg would have been. And then at the bottom of the page 4, you have FC, and I take it that is Fred Charles. Is that correct?
Yes, sir.
And that was Mr. Colson?
Yes, sir.
And his
Mr.
question...
Dash, for the record, it was Mr. Colson who recorded the telephone call, not myself.
Yes, your statement for the record is that the call was recorded by Mr. Colson.
Yes, sir.
And Fred Charles, being Mr. Colson, stating, do you think that Ellsberg or Van had any connections with the drug trafficking? So that, would it be fair to say that there was at least an inquiry being made as to attempt at connecting Mr. Ellsberg with drug trafficking?
Yes, sir.
Now there was some, if you turn to page 6, the transcript indicates that you were asking questions of Colonel Coneen concerning certain cables, State Department cables. Could you instruct the committee as to what the purpose of your requests of Colonel Coneen were being led to?
I would never attempt to instruct the committee, Mr. Dash. I would attempt to inform...
Would you assist the committee?
Yes, sir. Mr. Colson and I were jointly interested in the circumstances that led up to the assassination of the president and I believe the premier of South Vietnam. We felt that somewhere there should be an instructive record of exchanges between Washington and Saigon. We knew also that there were several channels that could have been utilized. In addition to the normal State Department communications with its embassy, there was the normal CIA communication channel with its station in Saigon. There were also so-called back-channel communications facilities for both organizations. There were communication cable facilities between.
That's not what I really was directing your attention to, and perhaps this question might make it clearer. Was there an effort on the part of your questioning of Colonel Cunneen to attempt to get some indication from Colonel Cunneen as to whether or not the Kennedy administration was related in any way to the coup?
What this line of questioning has to do with the presidential campaigns of 1972. It's very interesting, but I don't think it lies within the purview of the committee.
Senator Gurney, I think the following questions will indicate the line of questioning, which
could counsel simply state to the committee
yes.
What he has in mind?
I think Mr. Hunt will answer a few questions that will follow the questions that I'm now asking, which will show an effort by Mr. Colson to try to discredit the Kennedy administration and therefore the Democratic Party during the election and relating it to the assassination of Premier Diem and for that purpose attempting to bring the Catholic vote away from the Democratic Party and to show that a Democratic president had a role in the assassination of a Catholic premier.
But I thought this had to do with national security leaks that occurred way back in July 1971, this conversation. I can't see how that can possibly relate to the presidential campaign of 1972.
Well, the effort, and I think that Mr. Hunt has already responded to a question put by me to him, that the purpose was to get derogatory information and leak it to the press during the pendency of the presidential campaign.
Mr. Chairman.
And I think if I'm allowed to follow up with some questions, I think I can show the connection.
Mr. Chairman.
Yes.
Mr. Chairman, much of the information being covered by Mr. Dash and the point made by Mr. Gurney are involved in, I believe, the legal concept of whether or not the questions themselves should state a conclusion or whether they should elicit facts from which the committee may draw conclusions. In order to get the thing in some sort of order, I would suggest, if there is no objection, and I ask unanimous consent to that, the transcript of the telephone conversation in its entirety may be entered in the record at this time.
I intended to do that.
Is there any objection?
Let the record show that that the transcript of the entire telephone conversation is hereby made a part of the record
and
marked appropriate as an exhibit.
And, Mr. Chairman, rather than pursue the matter any further, might I simply suggest that the counsel for the committee attempt to establish the factual situation and, if need be, state in narrative form the purpose those questions are intended to serve without trying to build a statement of conclusion on the basis of each question. That, after all, is the fact-finding mission of the committee. I don't want to hornswoggle us by making strict rules of evidence, but I do think we'd get along faster if we could establish the facts and deal with the conclusions a little later.
Well, Mr. Chairman, I think my questions and the answers to the questions will establish the facts and will be quite relevant to the resolution under which this committee is operating. And I will go to another question which will clarify that.
Mr. Chairman, before we go on, does counsel understand what I'm saying?
Yes, I think I do.
Does counsel agree with it?
Well, I would like to ask a line of questions, Senator Baker, that will demonstrate the facts that, and the conclusions that the committee can draw, but I will not draw the conclusions. The committee will draw the conclusions.
Yes, well, do I understand then that counsel agrees with me that the conclusionary part of this thing is the function of the committee?
Oh, yes, but my statement concerning conclusions was a response to a question put by Senator Gurney as to what the relevance of the question was to our resolution, and therefore it was necessary for me to state the inference that was to be drawn from the questions that is relevant to our resolution. Otherwise, I could not respond to Senator Gurney's question.
Mr. Chairman, I make the request of counsel that we proceed as promptly as possible, stating the purpose for which the questions are asked without trying to establish a conclusion on the basis of each question. Now, counsel, of course, is free to accept that recommendation of the Vice Chairman or reject it, but I now place that before counsel for their consideration.
Well, Mr. Chairman, may I also make this observation? Actually, all this material we're talking about here and questioning about, we've had before the committee in one form or another. These are amplifications of that, but I really think what we ought to do to get along with the committee business is to get to something new and not to rehash something old. This isn't really a trial. We're not seeking to corroborate testimony or evidence we've heard before. What we're trying to do is to get at some new facts. And I would just suggest that following Mr. Baker's suggestion, possibly we could get this by a very short explanation of the counsel, plus putting it in the record, and then get on to new business.
Well, Mr. Chairman.
Just a moment. The evidence we've taken thus far indicates that Mr. Hunt had much to do with the matters the committee is investigating, and I think perhaps we'd make a little bit more speed if we'd just question the witness.
Mr. Hunt, before you proceed, Mr. Dash, Mr. Chairman, I agree with you, and I hope very much that we will simply question the witness and not try to build statements of conclusion as we go along. I fully intend to draw inferences and state conclusions of my own, but that will come on or about February 28th. So I hope that we can sharpen up questions to elicit facts without developing hypotheses as we proceed.
Well, that's my intention, Senator Baker, and that's what I've been trying to do. Now, at this early time of your employment at the White House, Mr. Hunt, did you have access to State Department cables covering the period of the Diem assassination?
I did.
Why did you have access to them?
Because I had requested such access and it had been granted me.
Now, in the review of these cables, did you notice any irregularity in the sequence?
I did.
And at what period did the gap in sequence occur?
The period immediately leading up to the assassination of the Premier of South Vietnam.
Did you show the cables to Mr. Colson and offer an interpretation of them?
I showed him copies of those chronological cables, yes, sir.
And what interpretation, if any, did you give him concerning the cables?
I told him that the construction I placed upon the absence of certain cables was that they had been abstracted from the files maintained by the Department of State in chronological fashion, and that while there was every reason to believe on the basis of the accumulated evidence of the cable documentation that the Kennedy administration was implicitly, if not explicitly, responsible for the assassination of Zim and his brother-in-law, that there was no hard evidence such as a cable emanating from the White House or a reply coming from Saigon, the Saigon embassy.
Well, what was Mr. Colson's reaction to your statement and the showing of the cables to him? Did he agree that the cables were sufficient evidence to show any relationship of the Kennedy administration and the assassination of
He
Kennedy?
did.
Did he ask you to do anything?
He suggested I might be able to improve upon the record.
And what did you understand him to mean when he said to improve upon the record?
To create, to fabricate cables that could substitute for the missing chronological cables.
Did you, in fact, fabricate cables for the purpose of indicating the relationship of the Kennedy administration and the assassination at the end?
I did.
And did you show these fabricated cables to Mr. Colson?
I did.
What was his response to the fabricated cables?
He indicated to me that he would be probably getting in touch with a member of the media, of the press, to whom he would show the cables.
And were you in fact put in touch with a member of the media?
I was.
And who was that?
Mr. William Lambert of Life magazine.
And what was your instructions concerning the relationship that you were to have with Mr. Lambert?
To show Mr. Lambert the cables in the context of the other legitimate cables that I had acquired from the Department of State, to permit Mr. Lambert to hand copy the texts of the fabricated cables, but I having warned Mr. Colson previously that the cables were not technically capable of withstanding professional scrutiny, that Mr. Lambert was not to be allowed to remove the cables for photocopying purposes.
Did Mr. Lambert use the information?
Not to my knowledge.
No. Now, are you aware from your conversations with Mr. Colson and the use of these cables, any strategy that Mr. Colson had with regard to Catholic voters?
Yes, sir.
Could you describe that more fully?
I believe it was desired by Mr. White, by Mr. Colson, or at least some of his colleagues, to demonstrate that a Catholic United States administration had in fact conspired in the assassination of a Catholic chief of state in another country.
Now, did you show the fabricated cables to Colonel Canine?
I did.
Under what circumstances?
Prior to Colonel Conine's appearance on a, I believe, NBC TV network special concerning Vietnam.
And did Colonel Canine use any of this information from the fabricated cables in his program?
I would have to answer in these terms, Mr. Dash, that I had shown him the fabricated cables in the broader context of the overall cables, legitimate cables, that he was then interrogated by a camera and interview crew, and that I believe he made, if not specific reference to the cables I had shown him, at least they reinforced his own belief that there had been direct complicity by the Kennedy administration in the events leading up to the assassination of the South Vietnamese premier.
All right, now, as part of Mr. Colson's plan to publicly discredit Mr. Ellsberg, did you prepare a derogatory article on Mr. Leonard Boudin, Ellsberg's lawyer?
I did.
And did you show this to Mr. Colson?
I did.
And what was his suggestion when you showed it to him?
He indicated that he would be passing the information to a member of the press, the article that I had prepared.
And did, in fact, the material that appeared in that article, was it reflected in any news story that you were aware of?
Yes.
Can you state to the committee what particular news story?
It was an article authored by Mr. Jerry Terhorst, who represented one of the Detroit newspapers in Washington. It formed the second half of a story that Mr. Terhorst was publishing on Ellsberg and Ellsberg's defense.
Now, did you subsequently, in a memorandum to Mr. Colson, suggest the manner in which additional derogatory information might be developed on Ellsberg and how a file might be constructed to destroy his public image and credibility?
Yes.
Do you have a copy that the committee provided you in executive session of a memorandum from you to Mr. Colson dated July 28, 1971, entitled Neutralization of Mr. Ellsberg?
I do.
Now, you'll notice in that memorandum, Mr. Hunt, that on item I think number 7, there is a reference to obtain Ellsberg's files from a psychiatrist analyst. Do you see that reference as one of the items?
I do.
Did you, at the time you made that recommendation, contemplate that it might be necessary to engage in a covert entry or a break-in?
I did.
Also, there is a reference that a psychological assessment from the CIA be requested of Mr. Ellsberg. Is that correct?
Yes, sir.
What was the purpose of the psychological assessment, Mr. Hunt?
One of the problems the administration was having with the Ellsberg indictment, I believe I'm probably being presumptuous in using so large a frame of reference, was that nobody really could comprehend why Ellsberg had done what he did, which was to take possession of and publicize documents of the highest classification and sensitivity. We knew that some had been made available to the Soviet Union by one means or another. Dr. Ellsberg's personally stated justification for having performed these acts was not comprehensible to any of us in the White House who were charged with determining his motivation and the manner of the leaks. I believe that it was my initial recommendation that we attempt to probe or plumb Dr. Ellsberg's mind by means of a covert psychological assessment. We had no idea what type of an animal we were dealing with.
Would it also be true, Mr. Hunt, that information that might be obtained from either the profile or psychiatric materials from his analyst might be used to discredit Mr. Ellsberg?
Might be used, yes, sir.
And if received, would that also be presented to the press media?
I would have to qualify my reply, Mr. Dash, by saying that it would depend upon the nature of the items that were discovered.
Yes. Now, do you know whether or not your recommendation on your memorandum on the neutralization of Mr. Ellsberg was implemented?
In terms of each item, sir?
Yeah, in terms of some of these items.
Well, I know that all overt press material on Ellsberg will continue to be collected. A request was levied on the Central Intelligence Agency for a covert psychological assessment of Dr. Ellsberg. I believe that the Central Intelligence Agency, the FBI, and perhaps the Counterintelligence Corps were requested to provide the Plumbers Group with their full holdings on Ellsberg. And in due course, we did enter the office of Dr. Fielding, who had been Dr. Ellsberg's psychiatrist, to determine if there were any psychiatric notes.
Now, Mr. Chairman, on this particular memorandum, July 28, 1971, from Mr. Hunt, Mr. Colson, the subject neutralization of Ellsberg, I'd like to have identified for the record and admitted in evidence.
It will be appropriately marked as an exhibit and is received in evidence as such.
Now, I think you've testified, and in your statement you've indicated that you indeed did engage in a break-in. Was it subsequently determined that an attempt should be made to obtain Dr. Ellsberg's medical files from the psychiatrist's office?
Yes, sir.
You have a memorandum which the committee provided you dated August 27, 1971, from Mr. Ehrlichman to Charles Colson, with the subject Hunt Liddy Special Project Number 1.
I have such a memorandum.
August 27th. I think this was previously put in the record by the committee, attached during Mr. Ehrlichman's testimony. I think I've just been informed there was Exhibit 91 in the committee record. Do you have a copy of that memorandum?
I beg your pardon?
Do you have a copy of that memorandum?
Yes, sir, I do.
Let me just read the memorandum. It's brief. This is from Mr. Ehrlichman to Mr. Colson. On the assumption that the proposed undertaking by Hunt and Liddy would be carried out and would be successful, I would appreciate receiving from you by next Wednesday a game plan as to how and when you believe the material should be used. This referring to Hunt Liddy Special Project Number 1. Mr. Hunt, what, from your understanding on the date of August 27, 1971, would Hunt and Liddy Special Project Number 1 be?
I would assume it to be the fielding entry based on the fact that Mr. Liddy and I, as of that date, would just have returned from our initial reconnaissance of Dr. Fielding's professional premises in Beverly Hills. And would have made and submitted a feasibility study.
And that the reference there for Hunt and Liddy Special Project Number 1 would refer to the proposed covert entry of Dr. Fielding's office for the psychiatric file.
Yes.
Now, in fact, you and Mr. Liddy did go to Los Angeles to determine whether a covert entry was feasible, and you concluded that it was, did you not?
Yes.
And in fact, you and Mr. Liddy and 3 Cuban Americans, Mr. Barker, Mr. Martinez, and Mr. Diego, did break into Dr. Fielding's office over the Labor Day weekend in 1971. Is that true?
With one limitation, that neither Mr. Liddy or I were ever in the premises of Dr. Fielding.
There are no files of Dr. Ellsberg were found. Is that true?
None were found, no, sir.
Now, you recruited Mr. Barker, Mr. Martinez, and Mr. Diego. Is that true?
Yes, sir. More specifically, I obtained Mr. Barker's cooperation, and he obtained the cooperation of Messrs. Martinez and De Diego.
What was your prior relationship with Mr. Barker?
Mr. Barker had assisted me during the CIA-sponsored effort, which came to be known as the Bay of Pigs operation.
Did you take photos of the inside of Dr. Fielding's office to show the forced open files?
No, sir.
Did somebody of the group take photos?
Yes, sir.
All right. Now, to whom were these photos shown?
They were shown within room 16 to Messrs. Krogh and Young.
Now, when you say room 16, Mr. Krogh and Young, by the time this program developed, which led up to the covert entry of Dr. Fielding's office, you had begun to work with Mr. Krogh, Mr. Young, and Mr. Liddy. Was not that so?
Yes, sir.
How did that occur? Because you originally, I think, testified that you were assigned to work for Mr. Colson. How did the transfer of relationship and assignment take place?
Through a process resembling osmosis, almost. I had discovered early in my reading of the overt materials relating to the publication of the Pentagon Papers, my researches into Dr. Ellsberg's background, that considerably more documentation would be necessary for my purposes. I so advised or informed Mr. Colson, and he told me that these materials, that is to say classified materials bearing on my researches, were to be found in room 16, and I should check with Mr. Liddy for that purpose. I found that the holdings that were in room 16 were quite extensive, and I began, as a matter of course and custom, to go there every day to acquaint myself with additional information as it flowed into room 16 from the various government agencies that were making contributions. So it was that I spent less and less time in Office 338, which had been assigned me by Mr. Colson, and a great deal more time in room 16, which became known as the Plumbers Unit, the Special Investigations Unit.
And by the time you had filed your memorandum on neutralization of Mr. Ellsberg, you at this time were working with the so-called plumbers?
Almost entirely, yes, sir.
Yes. Now, did you attempt to show the photographs that were taken during the Fielding break-in to Mr. Colson?
I did.
Yes. And what occurred when you did?
I told Mr. Colson I would like to try to put a date on this, Mr.
Yes,
Dash.
Do you have a date for that?
Yes, I do.
While Howard Hunt checks his notes for exact dates of Plummer's activities, we're going to take a short break. Public television coverage of the Senate Watergate hearings will continue after a pause for station identification.
Unabridged coverage of these hearings is being broadcast as a public service by your local public television station. This is PBS, the Public Broadcasting Service.
NPACT continues its coverage of hearings by the Senate Select Committee on Presidential Campaign Activities. Here again, NPACT correspondent Jim Lehrer.
As we go back to the hearings now, Mr. Hunt is discussing his report following the break-in at the office of Daniel Ellsberg, psychiatrist.
On Labor Day weekend 1971, that is to say the 3rd of September, the entry in Dr. Fielding's office was accomplished. The following Tuesday, that is to say the first working day after Labor Day, was the morning on which I attempted to show Mr. Colson the Polaroid photographs that had been taken by team members of the violated cabinets in Dr. Fielding's premises.
And how did he react to your attempting to show him the photographs?
He declined to look at what I had in my hand, continued striding into his office without breaking his pace, and said, "I don't want to hear anything about it."
Now, were you assigned by Mr. Colson to interview a Mr. Clifton DeMont of Providence, being told by Mr. Colson or anybody else that Mr. DeMont allegedly had derogatory information on the Kennedy family?
Yes.
When was this?
I would say approximately late July of 1971.
Now, is it true that you undertook to have this interview with Mr. DeMont disguised?
Yes, sir.
And how did you obtain the materials for the disguise?
Through the Central Intelligence Agency.
And could you just very briefly tell the committee how you were able to obtain materials that would permit you to disguise yourself from the Central Intelligence Agency?
Shortly after my employment began at the White House, I reported to Mr. Colson that I had been given credible information to the effect that Mr. Clifton DeMott was believed to have information reflecting unfavorably upon certain members of the Kennedy political grouping. This having been based on the experience of an individual named Clifton DeMott, who had been an unofficial part of the Kennedy entourage during the, I believe, 1960 election. Mr. Colson felt that the lead ought to be followed up and asked me whether I could undertake to elicit information from him during an interview, with the proviso that my connection with the White House not be revealed. I said that this would require my having some sort of alias or false documentation and perhaps even physical disguise. Mr. Colson asked me whether or not I could provide it. I said I could not, and I in turn asked him whether or not such disguise documentation might be available through either the Secret Service or the FBI representatives at the White House. Mr. Colson indicated that the matter was too sensitive to involve either the Secret Service or the FBI, and he inquired whether perhaps on a man-to-man or personal basis I might not be able to acquire documentation and disguise equipment from former associates at the Central Intelligence Agency. I told him that this was out of the question. Mr. Colson then postulated the thought, or the question rather, what would be required to obtain the cooperation of CIA. I said that it had been my past experience that a call from the White House brought almost instant response from the Central Intelligence Agency. Mr. Colson said to me, very well, I'll look into it and get back to you.
All right, then how were you informed, and in what way were you notified that you could then go make contact with the CIA for the disguise?
The precise details at this
If you could just
point
briefly tell us that.
are not entirely clear. The crux of the matter is that I did receive at one point a call from Mr. Carl Wagner, who was the principal personal assistant to General Robert Cushman of the Marine Corps, who was then the deputy director of the Central Intelligence Agency, setting up an appointment for me with General Cushman at CIA headquarters.
And you did obtain disguise materials?
I did.
And so disguised, you did interview Mr. DeMott?
Yes, sir.
What was the outcome of that interview, Mr. Hunt?
It was determined by both Mr. Colson and myself that the information was useless.
Now, in the latter part of 1971, Mr. Hunt, did you become aware of the fact that Mr. Liddy was to become counsel for the Committee for the Re-election of the President?
I did.
And did Mr. Liddy recruit you to help him develop a large-scale covert political intelligence plan for the Committee to re-elect the President?
Yes.
When was this plan?
Excuse me, Mr. Dash.
Mr. Dash, could I trouble you to repeat the question? Having to do with recruitment.
What?
Which question? The question that he just answered before the last question, he would like repeated, please.
Perhaps the reporter can repeat the question.
Mr. Liddy recruit you to help him develop large-scale covert political intelligence plans for the committee to re-elect the President, MCA.
I would like to modify that response, if I might, Mr. Dash.
Yes.
In late November 1971, Mr. Liddy approached me saying that the Attorney General of the United States, Mr. John Mitchell, required the establishment of a large-scale intelligence and counterintelligence program, that he, Mr. Liddy, was about to become its chief, and Mr. Liddy would like to assure himself of my cooperation.
Was this the plan that came later to be known as Gemstone?
Yes, sir.
And I think, who did you understand from the conversation, Mr. Liddy, actually were directing the development of this political intelligence plan?
My understanding was as follows, that the plan had been proposed and or required by the Attorney General of the United States, Mr. Mitchell, that Messrs. John W. Dean III, then counsel to the President of the United States, and Mr. Jeb Stuart Magruder, a recent White House aide, were those who were active in its formulation.
Now, did you in fact help Mr. Liddy prepare the detailed plan and budget of this plan?
I did, with the exception of that portion of the plan which dealt with electronic surveillance.
Now, prior to the presentation of the plan, and Mr. Hunt, the committee has already had ample testimony concerning presentation of this particular plan to Attorney General, former Attorney General Mitchell, Mr. Dean, and Mr. Magruder by Mr. Liddy on January 27, 1972, and February 4, 1972. Now, prior to that presentation, prior to the January 27th presentation, did you have a discussion with Mr. Colson concerning that you would be giving fewer hours to the White House work because of the time that you would have to spend with Mr. Liddy?
I told Mr. Colson that because of the increased amount of time I was spending with Mr. Liddy, that I would be able to give far less time to Mr. Colson than I had been in the past.
And what, if anything, did Mr. Colson say to you about that?
He said that he understood this.
And did he indicate by any words or statement that he understood the plan that you were working with Mr. Liddy on?
Yes.
Could you give us a little fuller explanation of that?
On one occasion, and it must have been in conjunction with this particular interview, Mr. Colson told me that he had in fact supplied Mr. Mitchell with my bona fides. He further indicated that he was aware of the overall intelligence plan. His only problem with it was that he would much prefer to see me heading it rather than Mr. Liddy. I told him that the situation was fine as far as I was concerned, that I had cooperated with Mr. Liddy before. We got along well. I had already a full-time job with the public relations firm and was not seeking full-time employment such as Mr. Liddy had.
And is it true that this conversation took place in January prior to the January 27 meeting with former Attorney General Mitchell?
Whose meeting with...
Your meeting with Mr. Colson. When
yes,
did it take
yes,
place?
sir, but who met with Mr. Mitchell?
No, I said, did this meeting that you had with Mr. Colson take place in January prior to the January 27 presentation by Mr. Liddy of the plan to Attorney General Mitchell?
To the best of my recollection, it did.
And you know where the conversation with Mr. Colson took place?
Between myself and Mr. Colson?
Yes.
In Mr. Colson's office.
Now, did you tell Mr. Colson at that time that you planned to recruit and use members of the same Cuban-American community that had worked with you in the Ellsberg break-in?
Either on that or another occasion, Mr. Dash.
And Mr. Colson was aware, was he not, of the role you and Mr. Liddy played in the break-in at Dr. Fielding's office?
I was not so aware at the time. I have come to understand that subsequently.
Now, at the time that Mr. Colson was indicating to you that he was aware of an intelligence plan that Mr. Liddy was working on, was there any other intelligence plan besides the Gemstone plan that Mr. Liddy was working on?
No.
And was it your impression, therefore, that Mr. Colson was speaking of the so-called Gemstone plan?
Yes.
Now, Mr. Hunt, Mr. Colson has submitted this committee an affidavit. Do you have a copy of that? The committee, I think, has given you a copy. The affidavit signed by you, dated April 5, 1973, I think it's brief enough to read, as I, E. Howard Hunt, having been duly sworn, do hereby depose and state as follows. I understand that allegations and statements have been made to the effect that Charles Colson, former counsel to the President, had prior knowledge or in some way was involved in or participated in the break-in at the Democratic National Committee headquarters at the Watergate Hotel on June 17, 1972. I never had any time discussed with Mr. Colson any plans with respect to this incident. I have no knowledge whatever, personal or otherwise, that Mr. Colson had any prior knowledge whatever of this incident. To my knowledge, no one else ever discussed this matter with him prior to June 17, 1972. Did you sign this affidavit?
I did.
What were the circumstances which led you to sign this affidavit?
This affidavit was passed to me in the federal courthouse by my attorney, my then attorney, Mr. William O. Bittman, prior to an appearance of mine before the federal grand jury. To the best of my recollection, Mr. Bittman indicated to me that he had received the affidavit in draft form from Mr. Colson's office and wondered if there would be any problem on my part about signing it. I indicated that I had no difficulty with it whatever and did in fact sign the affidavit.
All right. Now, Mr. Hunt, does this affidavit that you signed negate the testimony that you've just given that Mr. Colson did inform you in January 72 that he was aware of what had come to be known as the Gemstone plan?
Does it negate it?
Does it negate it?
No, sir.
And could you explain why it does not?
Because the information that Mr. Colson possessed in January and that I possessed in January referred only to an overall intelligence program. It had nothing to do with a specific break-in at the Democratic National Headquarters.
And this particular affidavit deals only with Mr. Colson's knowledge of the specific break-in
at the
Watergate.
Yes, sir.
Mr. Chairman, I'd like to enter or have the affidavit identified as an exhibit of the committee and admitted in evidence.
The affidavit will be appropriately numbered and received in evidence as an exhibit.
Now, Mr. Hunt, is it not true that you only recently told the staff of this committee in executive session, specifically within the last week or two, of the fact of Mr. Colson's knowledge of the so-called Gemstone plan in January 72?
May I consult with counsel?
I think I certainly all along I had said that when Liddy left the premises, that I had said to him that he had said to me, I think I may have done some. Do you think that was an indication to me that Colson knew about it before that meeting as well? Maybe I better have him make one of those. I think, yeah, you better, but I think when he asked you if you didn't test him the first time, he told me, is he?
I would appreciate having the stenographer repeat the question.
Mr. Hunt, is it not true that you only recently told the staff of this committee in executive session, specifically within the last week or two, of the fact of Mr. Colson's knowledge of the so-called Gemstone break-in in January 72?
I didn't use the term break-in, the Gemstone plan in January 1972.
Gemstone plan. So the answer is yes to that? The answer is yes. It's a difficult question. It's a difficult question.
Well, why don't you recite and acknowledge? You say that you want to be sure you're accurate to me and say that you had told the committee when these conversations became out, but you had not told the committee Colson before that. It seems to me it's clear. Take your time. Be sure you're right.
In the interest of accuracy, Mr. Dash, let me say or repeat testimony I have given in the executive session to the effect that on an occasion when I introduced Mr. Liddy and Mr. Colson for the first time, following that particular meeting, Mr. Liddy said to me as we left Mr. Colson's office, I believe I may have done us some good, which was indicative to me that they had been discussing the Gemstone plan. However, only recently, and I have said that from the beginning of the interrogations, however, I have, within recent weeks, let us say, added to my testimony to state, in effect, to enable me to provide a positive response to the question you have just posed me.
Isn't that true, Mr. Hunt, that on May 14, 1973, in page 323 of the transcript, that in specific questions that I put to you, whether or not any other person than the persons who had been involved in the discussion with Mr. Liddy, and named persons such as Mr. Mitchell, Mr. Dean, Mr. Magruder, knew about the overall intelligence plan, let me just quote your statement on page 323, and my question. My question, during that time, did you ever indicate in the presence of Mr. McCord that these plans would have, that you were in touch with other persons yourself in the White House, Mr. Colson or anybody else concerning these plans? Mr. Hunt, no, sir, I would not have done that because it was true to the best of my knowledge. Mr. Colson had no specific knowledge. He had no knowledge of my dealings with Mr. Liddy from me. Now, if Mr. Colson had collateral knowledge of awareness, he did not confide in me. And what I'm asking, Mr. Liddy, is it not true that on May 14th, 1973, that your statement was that Mr. Colson did not, to your knowledge, have any awareness of an overall intelligence plan?
Have specific.
Excuse me, Mr. Chairman, I detect a little bit of confusion. If I could just have 1 minute to talk to Mr. Hunt, I think it might expedite this.
I have a feeling that you don't understand. I don't really understand what you're getting at. I wanted to get you to say what you told me the other day. All right. And to tell me that you had never told me that before. All right. Now, because you didn't come forward with it, he's going to go through the whole thing. Well, I don't want him to. Okay, can we reduce this to just a short question? Like, give me a yes answer. You had the papers and have explained to you, have clarified to you that the purpose of this question is a recent addition to your testimony concerning Colson's knowledge prior to that Liddy meeting. Yes, how can I handle all that? Well, you could just can't why don't you interpret the questions, you understand it, and then get him to accede to it and let me answer it.
Mr. Dash, if the committee will...
You might.
I think I have a notion, Mr. Dash, as to the line of questionings you are about to pursue in order to refresh Mr. Hunt's recollection as to the testimony he recently gave in executive session. And it was clear to me before you undertook this last question that he didn't quite clearly understand what you were driving at. And he and I have now discussed that briefly. And I think perhaps if you will ask your first question, or perhaps I could ask it, he could quickly answer it and we could go on to something else. I think what you were asking him is whether in the past few weeks he had added to his explanation of his conversations with Mr. Colson the fact that in January of 1972 there was a conversation between him and Mr. Colson which indicated that Mr. Colson had knowledge of the Gemstone program.
Yes, and...
I think he can answer that quickly.
Right, and the question was that I put to you is, isn't this the first time you've told the committee that?
Yes, sir.
Have you told any, prior to telling the committee that, have you informed any other investigative body, including the grand jury that is presently sitting, about that information?
No, sir.
Can you explain to the committee, Mr. Hunt, what appears to be contradictory testimony in the executive session and now before this committee as to Mr. Colson's prior knowledge of this general plan?
I can attempt to, Mr. Dash.
Would you please do that?
Yes, it derived as a result of repeated questioning by the committee staff concerning events which transpired on the occasion of my having introduced Mr. Liddy and Mr. Colson for the first time. A theory of Mr. Colson's perceptions of the meeting was entered into and developed, which brought back to my mind for the first time the prior conversation that I had held in January with Mr. Colson. And
Mr. Dash, may I ask that the record be clear that there is no contradiction between Mr. Hunt's testimony on this point today as against his testimony in the executive session? I think that might have been inferred from your question.
The record is clear on that. I again made it very clear that Mr. Hunt is testifying today consistently with what he's told the committee within in executive session the last week or two. And I was pointing out, in the interest of fairness, that Mr. Hunt had not given us this testimony in earlier occasions, and Mr. Hunt has just given us an explanation of why he had not. I would like to follow that up, Mr. Hunt, and ask you whether or not your motion that is now pending in the court for the removal of your plea of guilty, or withdrawal of your plea of guilty, in which you indicated in the motion that you believe that Mr. Colson approved the overall plan, has any relevance to your recent testimony before the executive session or before this committee?
I'm a little troubled, Mr. Dash, by your use of the word relevance.
Well,
you might want to ask me that.
I'll put the question more directly, Mr. Hunt. Are you now giving us your best recollection of what truthfully transpired in January, as opposed to what you were telling us earlier during the period of interrogation?
Yes.
I'm not clear. I got lost about 10 minutes ago. Is the burden of the query that Mr. Hunt is now giving us information for the first time and only recently gave it to us in executive session, as distinguished from his earlier appearances in executive session, by reason of or connected with the fact that he is attempting to change his plea from guilty to not guilty?
Yes. And
now, is there any implication in counsel's question that the two are inconsistent, but that rather this is additional information that may have bearing on the application of Mr. Hunt to change?
Well, the last question that I put to Mr. Hunt, and perhaps he can answer it, is there any motivation on your part to give us this more recent testimony concerning Mr. Colson's awareness of the plan connected in any way to your motion to withdraw your plea of guilty?
No, sir, and if I may consult with counsel, there's another point I would like to make pertinent to this. I would like to add, Mr. Dash, that my legal position vis-a-vis the motion does not depend upon Mr. Colson's knowledge or non-knowledge at that time.
All right. Now, Mr. Hunt, after the February 4th meeting that Mr. Liddy had with the former Attorney General, in which there was another turn down on the so-called Liddy plan, did Mr. Liddy ask you to introduce him to Mr. Colson?
He did.
And what reasons did he give you for this?
He indicated to me that, first of all, he admired Chuck Colson as a man who got things done. He expressed his own desire for a substantial position in the forthcoming administration. He indicated to me that inasmuch as John Mitchell would be leaving the administration and he, Liddy, was known and identified as a Mitchell man, that Mr. Liddy would like to touch base with Mr. Colson, who would be staying on in the administration, at least through the election, and so have another power base, as it were, on which he could depend at such time.
Well, did you arrange such a meeting?
I did.
And do you know when that approximately took place?
No, sir.
But what do you recall? It was in the month of February?
May I consult my notes, Mr. Dash? I would relate it to the phone call concerning which Mr. Magruder has already given testimony.
All right, now did you introduce Mr. Liddy to Mr. Colson?
I did.
After you did, what did you do?
I withdrew to the back of the room and sat, smoked my pipe, leafing through a magazine while Mr. Liddy conversed with Mr. Colson.
And why did you withdraw to the back of the room?
Mr. Liddy having given me the preamble, the reasons for his desire to meet Mr. Colson, I felt that it was a personal matter and did not want to involve myself or interpose myself in any way.
How long did the meeting take place, Mr. Hunt?
Approximately 10, 12 minutes.
Did you observe Mr. Colson use the telephone during that meeting?
On several occasions.
Yes. After the meeting, did you have a conversation with Mr. Liddy?
I did.
What did Mr. Liddy tell you?
He said, quote, "I think I may have done us some good," unquote.
At that time, what was your interpretation of that message?
I realized that he had been speaking with Mr. Colson about the Gemstone operation.
Why? Why did you draw that interpretation from the statement, I think I've done us some good?
Because that was the only common subject concerning which he could have done us any good.
All right, now the committee has already heard testimony from Mr. Magruder that while you were in Mr. Colson's office, Mr. Colson telephoned Mr. Magruder and urged him, quote, to get off the stick and get the budget approved for Mr. Liddy's plans. Now, what plans of Mr. Liddy could Mr. Colson have been referring to at that time?
Could only have been the Gemstone concept.
Why do you say that?
That was the only one that was under consideration.
Now, during part of this period, Mr. Hunt, when you were working for Mr. Liddy between December 1971 and March 72, did you receive any other assignments from Mr. Liddy for political espionage against Democratic candidates for the presidency? Specifically, did you have dealings with a person known to you as Fat Jack?
Yes, sir.
Could you describe how these dealings took place, what the assignment was?
There came a time when Mr. Liddy asked me as an accommodation to meet with a gentleman who was handling an agent inside Muskie headquarters. He described the gentleman's physical appearance. We arranged a meeting point in front of the Roger Smith Hotel. I gather that Mr. Liddy also described my appearance to the other gentleman, so that at the appointed time we had no difficulty in recognizing each other.
What was the purpose of these meetings?
So that I could pick up material that derived from Muskie headquarters from this penetration agent.
What kind of materials, Mr. Hunt, were these?
They were in photographic form.
And could you describe the nature of the photographs?
On only one occasion did I look into the envelope. I saw that there were advanced schedules, perhaps some policy statements, material of medium value, I would say.
Was the person you knew as Fat Jack paid for this work?
I have no way of knowing.
Did you, at any time in any envelope that you delivered, see any money?
Yes.
And was that given to him?
It was. My understanding, to amplify that point from Mr. Dash, was that the money was to go to pay for the photographic services that had been rendered to Fat Jack.
Did you know who he was in touch with?
No.
Did you have any knowledge at that time or at this date of the real identity of the person you knew as Fat Jack?
No.
Did you yourself recruit a person to infiltrate the campaign of a Democratic presidential candidate?
I did.
And could you tell us who and in what campaign?
His name was Thomas Gregory. He was a student whom I recruited to pose as a volunteer to work inside Muskie headquarters.
And what was his assignment?
His assignment was to acquire for us policy papers, working papers, advanced schedules of the Muskie Party, lists of contributions of contributors, bank statements, that sort of thing that would normally flow out of a political campaign headquarters.
And did there come a time when you transferred Mr. Gregory to the McGovern campaign?
There did.
And what was his assignment there?
It was the same with one addition.
What was the addition?
The addition was to prepare for an electronic surveillance or electronic penetration of McGovern headquarters.
And how was he to prepare for that?
He prepared for it initially by providing me with a floor diagram of the McGovern office building. I introduced Mr. Gregory and Mr. McCord, who I, in April, met for the first time. Mr. McCord then told Mr. Gregory what would be required to satisfy his own particular technical interests. Mr. Gregory took Mr. McCord through the McGovern headquarters. They continued, as it were, doing business between themselves in connection with the electronic surveillance attempt.
Was there, in fact, an attempt to break into the McGovern campaign headquarters?
There was an attempt to enter it, yes, sir.
Yes. What happened?
It was unsuccessful.
Now, was this activity part of the overall Gemstone plan?
Yes.
Now, during the same period and prior to the Watergate break-in, Mr. Hunt, did you and Mr. Liddy work on a political espionage plan involving a target in Las Vegas?
Apart from Gemstone?
Yes.
Yes.
What was the target and how did you learn about it?
Excuse me. I take it, Mr. Dash, you have no objection to my reciting this chronologically?
Yes. I have no objection to you responding to my question in the best way you can.
Yes, sir. There came a time when my employer, Mr. Robert Bennett, informed me that he had heard a rumor around Las Vegas to the effect that a publisher named Hank Greenspun had information which could, quote, blow Muskie out of the water in case Muskie became a candidate. I reported by very brief memo this information to Mr. Liddy. Mr. Liddy responded enthusiastically, seeing in it initially an opportunity for us to travel at the company expense, as it were, to Las Vegas and have an enjoyable time. Very shortly there, after his initial reaction, Mr. Liddy informed me that he in effect had been able to confirm the rumor, or at least that he had heard from another source this rumor, and that there was a disposition on the part of his principals to pursue it. I reported this matter back to Mr. Bennett, and within a short period of time, Mr. Bennett introduced me to a Mr. Ralph Winty, who was then the head of security for either the Hughes Tool Company or one of its many subsidiaries. At our initial discussion, Mr. Bennett, Mr. Winty, and I discussed Las Vegas, the Nevada political situation, the litigation then in progress and perhaps still in progress between Robert Mayhew, Mr. Hughes, the position, politically speaking, vis-a-vis Mr. Greenspun and Mr. Hughes, the allegation that Mr. Greenspun or others had bribed or bought certain judges in Nevada, and so on. This discussion reached the point where Mr. Bennett suggested that there was a commonality of interest between the Hughes Tool Company and Mr. Liddy and myself. And Mr. Winty and I withdrew to my office where he indicated that he was disposed to cooperate with me in the matter. I had no prior experience of Las Vegas, and he said that he would attempt to produce a floor diagram of the Greenspun office. I asked him whether his firm, with its multitudinous interests in Las Vegas, could provide us with support facilities such as hotel rooms, automobiles, and so forth. He indicated that would be no problem.
All right. Now, in other words, what you're saying is that your conversation with Mr. Winnie indicated that the Hughes 2 company also was interested in gaining information that may be in the possession of Mr. Greenspun that was related to their lawsuits that were pending. Is that true?
Yes, sir.
And that you were asking for assistance from them with regard to their resources out in Las Vegas.
Yes, sir.
Did that include an airplane or escape plane, should that be necessary?
That came later, Mr. Dash.
I'm just trying to...
the answer is yes, but
yes.
All
right, during this discussion, therefore, did you, by the way, go out to Los Angeles and further communicate with Mr. Winnie?
I did.
And was that for the purpose of determining whether or not you could agree on a plan to make an entry and locate a safe in the Greenspun office?
I would have to answer in this form, Mr. Dash, that there came a time approximately 2 weeks later, following my first meeting with Mr. Winnie, that Mr. Liddy and I had other reasons to go to the West Coast, and I informed Mr. Winnie that we would be at the Beverly Wilshire Hotel on a particular date. At that time, Mr. Winnie joined us, and I introduced him to Mr. Liddy, I believe under pseudonym, for the first time. During the course of that conversation, the question of an aircraft was aired for the first time.
And was it part of the plan, should it follow through, and should there be a safe, that there would be an entry, and that the contents of the safe would be emptied, and at a different place you would divvy up what belonged to Hughes and what belonged to your interest?
Yes, sir.
What happened to that plan? Did it ever was it fruitful?
Mr. Winnie had indicated to me that, and to Mr. Liddy also, that he could provide the on-the-ground support facilities that would be required for an entry operation, if such an entry operation were devised, but that with regard to the aircraft, he would have to refer to his superiors for authorization. It so happened that following the meeting among Mr. Winnie, Mr. Liddy, and myself, the Muskie candidacy was rapidly losing impetus, and no one was particularly interested in the information that Mr. Greenspun might have possessed, if in fact he ever did, concerning Mr. Muskie.
And so the plan was dropped?
The plan was dropped, and either Mr. Bennett or Mr. Winnie told me at a later date that in any event the availability of the aircraft had been declined.
All right, now, Mr. Hunt, with regard to the Democratic Convention in Miami, did you give any assignments to Mr. Barker?
I did.
And what, if any, assignment did you give to Mr. Barker?
We're speaking now only of the Democratic Convention, are we not? Mr. Barker's principal assignment was to develop a network of informants along the Miami Beach hotel complex who could report to us concerning campaign developments, convention developments, policies of individual Democratic candidates.
Did he also have an assignment to procure a houseboat as a base for electronic surveillance?
Yes.
And did he also have an assignment to recruit some persons who might be disreputable-looking young men, hippies, to pose as McGovern supporters?
Yes.
And what were they supposed to do?
They were supposed to demonstrate in front of the Doral Hotel some evening and behave outrageously to bring discredit upon the bulk of youthful McGovern supporters.
Now, Mr. Hunt, I think you, in fact, did participate in the break-in of the Democratic National Committee headquarters at the Watergate on about May 27, 1972. Is that not true?
I don't know what the word participate embraces.
You were not you did not make an entry yourself.
No, sir.
But you were
I participated in it, yes, sir.
And is it not true that you recruited Mr. Barker to bring up a team of Cuban Americans to assist in this plan?
Yes, sir.
And that is it true that it was his job to engage in photographing Democratic Party documents?
Yes, sir.
Now, it is true, is it not, that you also participated in the second break-in using the participating, as we indicated before, that you yourself did not break in, of the Democratic National Committee headquarters at the Watergate on June 17, 1972?
Yes.
Where were you situated, Mr. Hunt, when the entry team was arrested?
In room 214 in the Watergate Hotel, which is another building.
What did you do immediately after you were aware that an arrest had taken place?
I closed up Mr. McCord's briefcase, which contained electronic equipment, and with Mr. Liddy, we left the premises. I drove to the White House, where I inserted the briefcase belonging to Mr. McCord into my two-drawer safe. I went, I believe I called Mr. Douglas Caddy's apartment, he being an attorney.
Who was Mr. Caddy?
Mr. Douglas Caddy, an attorney and former employee of the Mullen Company, and asked him if he could receive me at that early hour in the morning.
Did you take any money out of the safe?
Yes, sir, I did.
How much?
I took out $10,000.
What was that money? Where did you get that money?
That was contingency money that had been provided me by Mr. Liddy.
For contingency just in case there was this kind of trouble?
Yes, sir, in case there was a mishap.
And what did you do with that money?
I took it during the course of the early morning to Mr. Caddy's apartment and gave it to him on behalf of the 5 men who had been arrested.
Now, did you make an analysis or review of the contents of your safe at that time or at a later time?
No, sir, not at that time.
When did you, if you did?
Excuse me.
Mr. Hunt, this might help you. Do you recall returning to your office at the EOB and looking through the contents of your safe?
Yes, sir.
And you recall that that was on or about June 19th, 1972?
Yes, sir.
Did you, what was, just very briefly, can you describe the contents of your safe at that time? What you have in there?
There's a great deal of material, Mr.
Just by categories.
There were the fabricated Vietnamese cables that I had shown to Mr. Colson, Mr. Coneen, and Mr. Lambert. There was material relating to Gemstone. There were transcripts of my conversations with Mr. Clifton DeMott, for example. There was a very substantial amount of material, part of which was shown me at the time of discovery by the United States attorney. Perhaps I'm not being responsive.
No, that's right. You're being responsive. Did it also include the briefcase, which included Mr. McCord's electronic equipment?
Oh, yes, that was there.
Now, did you inform anyone on that day of the contents of your safe?
I did.
Who was that?
Mr. Colson's secretary.
What's her name?
Her name was Mrs. Joan Hall.
And did you characterize or say anything about the contents? What did you say?
I did. Before I left the White House for the last time, I stopped by Mr. Colson's office, not to see him, but simply to inform Mrs. Hall, whom I knew held a combination of my safe, that it contained sensitive material. I simply said to her, I just want you to know that that safe is loaded.
Now, did you hear from Mr. Liddy during this period of time?
Which period of time, sir?
Shortly after, around June 19th or around that time?
Yes, sir, I did.
And what, if anything, did he tell you?
Toward midday on the 19th, I got a telephone call from him at my Mullen and Company office saying that he needed urgently to meet me, and we met on the corner at the USIA building, which I believe is 17th of Pennsylvania Avenue. We met, walked around the block. During the course of the conversation, he told me that it was necessary for me to get out of town, that they, quote, unquote, wanted me to get out of town.
Did he indicate who they were?
Not at that time.
Right. And then, was it a fact that that particular order was rescinded?
He told me that it was.
Yes. Now, in fact, you did leave Washington, did you not?
I did.
And did you ultimately go to California?
I did.
And at that time, did you make arrangements to obtain counsel?
I obtained local counsel in California, but not Washington counsel.
Well, through local, in California, who did you meet? What California counsel?
I was staying at the home of an attorney, an old friend named Morton B. Jackson. Mr. Liddy appeared out there unannounced on the 21st of June. I reiterated my request to him that he or somebody obtain counsel for me in the Washington area. Mr. Liddy gave me $1,000 and said this will help with Jackson. I then thereupon gave the $1,000 in cash to Mr. Jackson, retaining him as my counsel on the West Coast.
And did Mr. Jackson refer you to any Washington lawyer?
In due course, he did.
Yes, and what lawyer was that?
He referred me sometime later to two attorneys, neither of whom were known to, I believe, either Mr. Jackson or myself. Simply through an alphabetical process, I decided to retain to inquire of Mr. Bittman whether or not he would be interested in representing me.
And did you retain Mr. Bittman, William Bittman?
I did.
And when did you first meet Mr. Bittman in Washington?
On the night of July 3rd.
Now, what was your understanding, Mr. Hunt, concerning legal fees in support of your family that you would receive? What general understanding did you have?
At the time Mr. Liddy appeared at the home of Mr. Jackson on the 21st of June, I raised the question with him, as I had with several other people since I had left Washington, concerning counsel. Furthermore, how counsel fees, living expenses, and so forth are going to be taken care of. Mr. Liddy said, don't worry about that. It's all going to be taken care of just like the company or the agency. To me, that meant in traditional CIA or clandestine services fashion. He then produced $1,000, which was pretty hard evidence that there was money available for this sort of thing.
Later...
Might I
yes.
just continue one thought? So I said to him, well, by now the paralysis that gripped the White House and CREP in the wake of the arrest must have ebbed to some extent. Please tell me, who is the action officer now? And he said, it's Mardian, or at least it was as of the time that I left this morning. And I found that encouraging news.
Well, now, when you returned to Washington and you retained Mr. Bittman, did there come a time when Mrs. Hunt, your wife, had a contact with Mr. O'Brien, Paul O'Brien, at the Committee to Re-elect the President?
I believe she had that contact with Mr. O'Brien before I returned to the East Coast.
And what was the purpose of that contact?
To continue to seek counsel and to make sure that the arrested men and those of us who were still out would be taken care of in customary fashion.
Well, to your knowledge, was she assured by Mr. O'Brien that support money for counsel and for the family would be forthcoming?
I don't believe that she received that sort of assurances from Mr. O'Brien. As I recall her relating the incident to me, Mr. O'Brien was horrified by the revelations, but said he would look into them.
And you say horrified by the revelations. What revelations?
The revelations that my wife had given him.
Well, do you know what revelations your wife had given Mr. O'Brien?
I understand, and again, this is only hearsay from my late wife, was that she had told him that we had been acting on the behalf of the Attorney General of the United States and the Counsel to the President of the United States, that we had been apprehended. Men were in jail at bond money, bail money, counsel fees, all that sort of thing were needed and needed immediately. And my understanding is that this all was news to Mr. O'Brien at that time. He did say, however, that he would look into the matter immediately.
Now, there did come a time, did there not, after you had retained Mr. Bittman, that you received a call, or Mrs. Hunt received a call from Mr. Rivers?
Yes.
And what did Mr. Rivers have to say to your knowledge?
My late wife reported to me that, and we're skipping now over the authentication of Mr. Rivers. In any event, when Mrs. Hunt responded to the gentleman whose operational alias we knew was Rivers and knew him to be an appropriate person for him to deal with,
Well, when you say that we're skipping the authentication, are you...
We're skipping over his authentication.
Yes. Was a call first made by Mr. Rivers to Mr. Bittman?
Yes.
And what was Mr. Bittman's reaction to that call?
He rejected it and declined to speak of Mr. Rivers.
And then what did he do thereafter?
Within a day or so, he had occasion to be in conference with Mr. Paul O'Brien and possibly Mr. Parkinson, and mentioned this call as a curious matter. I believe at that point he was assured that Mr. Rivers was an appropriate person for Mrs. Hunt to be in touch with.
And then again, was there a call? Is that when Mr. Bittman called you at Mrs. Hunt?
Yes.
And what arrangements were made at that time?
That Mrs. Hunt, excuse me.
You mean arrangements with regard to further contact with Mr. Rivers?
Yes.
That by means of the usage of public telephones, Mrs. Hunt and Mr. Rivers would speak with each other, which in fact they did.
All right, were you aware that payments were in fact made by Mr. Rivers to Mrs. Hunt?
Yes.
By the way, I think the record will show that we've already had testimony as to the identity of Mr. Rivers as Mr. Tony Ulasewicz. Did you know, by the way, at the time that Mr. Rivers was a Mr. Tony Ulasewicz?
No, sir.
Did you have occasion to see a series of accounts or a couple of accounts that Mrs. Hunt made to Mr. Bittman concerning payments that she received from Mr. Rivers?
Only recently.
And was that by this committee?
Yes.
Now,
I would like to say I have been shown copies by the committee. I have been shown what purported to be originals by Mr. Bittman, who I believe it was submitting them to the grand jury.
Right. And did they indicate to you that payments were made covering Mr. McCord, Mr. Barker, and the other persons who had been arrested?
Yes.
Did there come a time, Mr. Hunt, when you went to your attorney, Mr. Bittman, and tell him that you wanted to plead guilty?
Yes.
What was the occasion for that?
I had made up my mind following in fact, during my return flight from Chicago after the death of my wife. That was on December 10th. My wife was killed in a plane crash at Midway Airport on December 8th.
And in fact, you did enter a plea of guilty?
I did.
After your wife's death, did you receive a call from Mr. Bittman concerning funds that he had for you?
I did.
And did you receive those funds?
I did.
Do you recall how much that was?
On the first occasion?
Yes.
Or do you want it seriatim?
Do you have them in seriatim? Perhaps we can expedite this by you just giving us a very brief statement of the funds that you did receive through Mr. Bittman.
On the 3rd of July, 1972, I retained Mr. Bittman with a $1,000 cash payment. Some days later, Mr. Bittman reported to me in a letter and also verbally that he had received the sum of $25,000 as a further retainer. He indicated the money had come to him anonymously and had been delivered to his office, that it was to be used on my behalf and considered as a retainer. Later on, perhaps in the month of October, I have no date for this, I was informed by Mr. Bittman that an envelope had been delivered to his office for me. I opened the envelope in his presence and counted out $20,000, which I turned over to him. Early in January or late December of 72, January of 73 or late December of 72, Mr. Bittman telephoned me to inform me that he had received an envelope at his house. He told me that this had been left in his mailbox. Previous telephonic instructions were to the effect that it was an envelope for me. I received the envelope unopened from his hands. I took it to my home and found that it contained $15,000. I gave $12,000 of those funds to Dr. Manuel Artime to assist with the defense funds of the foremen from Miami. It having been my prior understanding from a conversation with my wife that a committee was being formed in Miami for the defense of the 4 Miami men, then I subtracted $3,000, which she had told me she had placed at the disposition of other defendants from our own funds, and thereby reimbursed myself to the extent of $3,000, and the rest went to Miami.
Mr. Hunt, I think it might expedite matters if you do have a record of that, if you could provide the committee with a record of those payments. And let me just ask you, you have the total figure that you paid Mr. Bittman by way of a fee that you received through these means?
That I received how, sir?
That you received through the support money that was coming in either through Mr. Rivers or through any other source.
I'm not sure I understand.
Well, I'm asking for the total amount of money that you paid Mr. Bittman in legal fees.
That Mr. Bittman was paid?
Yes, well, that Mr. Bittman was paid.
$156,000.
And would you submit to us a statement of the details which you were giving us just a little moment ago? I think would help us expedite the questioning.
We'll be glad to.
Yes. Now, did you ever call Mr. Colson to complain about the problems of the payment of fees?
I did.
And you recall when you made that call?
On November 24th last.
Now, do you have a copy of that, of a transcript that Mr. Colson made of the telephone call?
I do.
Yeah. During that call, what in effect were you telling Mr. Colson? Why did you make that call?
I made the call, Mr. Dash, because my wife had indicated to me that because she had been placed in a very false and difficult position vis-a-vis the Cubans and the other people who were or had become her, quote, clients, unquote, she was unwilling to continue in the role that she had agreed to accept at the urging of Mr. Rivers, that is to say, to be the go-between. She felt also that perhaps because she was a woman, her words, her urgings, her representations were receiving insufficient weight or were not being seriously enough received by whoever the sponsors were, and it was in that spirit that she asked me to communicate with Mr. Colson, which I did.
All right, now on page 3 of that transcript, did you say the following? All right, now we've set a deadline now for close of business on the 25th of November, and I take it that's a deadline to receive funds, for the resolution on the liquidation of everything that's outstanding. And this, they're now talking about promises from July and August. It just has been an apparent unconcern. Of course, we can understand some hesitancy prior to the election, but there doesn't seem to be any of that now. Of course, we're well aware of the upcoming problems of the Senate and. Did you make that statement during that call? Does this transcript, by the way, reflect to your recollection the conversation you had with Mr. Colson? You recall that we showed you that transcript during the executive session.
I do, Mr. Dash.
You've had a chance to read it.
Yes, sir.
Yes. And what is your answer to my question as to whether that statement was made? It appears in the transcript.
I have no specific recollection of making the statement, Mr. Dash. However, inasmuch as it appears in a transcript, I accept it in good faith and will say under those circumstances that I made the statement.
And I'll just make one further reference. On page 5, if you look at the large paragraph at the top, and where you say, well, that's fine, for we're protecting the guys who are really responsible. But now that's, and of course that's a continuing requirement. But at the same time, this is a two-way street. And as I said before, we think that now is the time when a move should be made, and surely the cheapest commodity available is money. You see that statement?
Yes, sir.
And would you adopt that as something that you would have said during that conversation?
Yes, sir.
That as one that you would have said or that you did
say in the transcript.
I will accept it as a statement that I made.
Now, after you stopped receiving funds from various supporting sources, did Mr. Bittman ask for more funds from you?
Mr. Bittman informed me of the current state of my deficit balance with him, yes.
Mr. Chairman, I should have this conversation with Howard Hunt late November 1972, which is that was recorded by Mr. Colson, identified as an exhibit and entered in evidence.
It will be received in evidence as an exhibit and appropriately numbered as such.
Mr. Chairman, could I ask a question about it, just very briefly? Mr. Hunt, were you aware that this conversation was being recorded?
No, sir.
How did you come to know of its existence?
I can't recall whether I learned about it through the grand jurors or through this committee.
Could I ask counsel how we received it?
Oh, we received this from Mr. Colson.
From Mr. Colson?
Yes, from Mr. Colson.
I might say I felt that in retrospect, that I was set up on this one.
I'm sorry, I didn't hear you.
That I was set up, as it were, because I had requested an opportunity to speak with Mr. Colson, and the message I got back was that if I would call him from the phone booth at a particular time on a particular day, he would speak with me. Obviously, he had his recording equipment running at that time.
Do you have any reason to suspect that any part of the transcript is not correct?
No, sir.
Thank you.
But it is true, in following up on your statement, that you may have been set up, having had a chance to read this transcript. Is it not true that throughout the transcript, Mr. Colson repeatedly says to you whenever you wish to give him any facts that he doesn't want to hear anything about the facts, not to tell him anything? And
Yes, sir.
That goes through the entire transcript.
Certainly does.
I think I asked you, did Mr. Bittman ask you for any additional funds after the support money had stopped? I don't know if you would answer.
I thought I'd reply to that question, Mr. Dash.
Could you? I didn't hear your answer.
Mr. Bittman kept me informed from time to time of the state of my deficit balance with his firm. I did not interpret that as a demand for funds, but rather he was keeping me informed of how much money was owed. At that juncture, I was not considering debts owed to Hogan and Hartson as being personal debts of mine, although I came later to accept them in that spirit. I felt that they should be paid by the people or groups who had sponsored our Gemstone program. And I encouraged Mr. Bittman to turn to others for the payment of his fees rather than myself.
Now, there came a time when Mr. Bittman was required to withdraw as your counsel, did there not?
Yes.
And you retained...
Excuse me a minute. Mr. Dash, I don't know that I can say of my own knowledge that he was required to withdraw as my counsel.
I meant required by his own action. He did withdraw as your counsel, did he not?
He did.
That was not your action. You did not...
No, sir.
Right. You did not... This was his own volitional action.
Yes,
right.
sir.
To your knowledge. And then you've retained, and as Mr. Sachs, the counsel, you retained immediately thereafter.
Yes, sir.
Did there come a time, Mr. Hunt, when you wrote to Mr. Colson concerning the problems that you were having, wrote a letter to him?
Yes, sir.
What was the occasion of that letter?
I believe the letter, if it...
Do you have a copy of it, a copy of a letter dated December 31, 1972?
December 31st?
Yes, December 31st.
Yes, sir. I believe the letter is self-explanatory.
Right, and this letter followed the death of your wife?
Yes, sir.
And was it a letter in which you were again asking for assistance from Mr. Colson?
In effect, yes, sir.
Now, what did you get any response from Mr. Colson after writing that letter?
Indirectly.
Well, how indirectly? What kind of response? Who contacted you?
Through counsel.
Yes, and what did he tell you?
That Mr. Colson would be meeting with him on, I believe, the 3rd or 4th of January.
And did Mr. Bittman and Mr. Colson meet?
I understand that they did.
And did Mr. Bittman give you the results of that meeting?
He did.
And what, if anything, did Mr. Bittman tell you about the meeting you had with Mr. Colson?
First of all, that Mr. Colson was a great and good friend of mine, that he so considered himself to be, that I was a fine patriotic fellow, that if worst came to worst, he would take my children into his own home, that he was very sorry that I had ever become involved in this entire scheme. The other two matters, I ought to say parenthetically, that I had asked Mr. Bittman, well, first of all, the rationale for the meeting. To understand Mr. Colson's response, I really should go back a little, Mr. Dash. I had asked Mr. Colson to receive Mr. Bittman for the following reasons. One, I wanted Mr. Colson to be very sure about the reasons for my plea of guilty. I wanted him to understand all the circumstances, the factors that had weighed on me in making my plea, or plea I was about to make. Secondly, there were two CIA matters which were unresolved and which I felt White House intervention could be, to say the least, very useful. Thirdly, there was an active motion on part of my counsel for the suppression of certain evidence obtained from my White House safe through the unorthodox drilling and seizure procedures that had been employed by Mr. Dean and company. And I wanted all of these matters discussed with Mr. Colson at that time. What Mr. Bittman reported back to me, I have already indicated to you. I got no information from him concerning Mr. Colson's assistance with the CIA matters, which had to do with my annuity and the changes of survivorship benefits for my annuity, other than to say that Mr. Colson would always be delighted to help me to the extent that he could, whether as a private citizen or in the White House, but purely as a personal matter. The suppression motion, I do not think was reported back to me until the following day, when after Mr. Bittman and Mr. Colson had met a second time.
Did you ask Mr. Bittman to transmit any message from you on your plea of guilty decision concerning the length of sentence you might obtain, or any clemency or consideration that the government might give you if you pleaded guilty?
No, sir.
Mr. Chairman, the letter of December 31st, which precipitated the meeting between Mr. Bittman and Mr. Colson, I'd like to have identified as an exhibit and entered in evidence.
It'll be received in evidence as an exhibit and appropriately numbered as such.
Excuse me, Mr. Dash. May I ask when the committee plans to recess?
15 minutes.
12:30.
12:30. Mr. Chairman, I'd like to just pose a question to the witness, since he's been relating conversations between he and Mr. Bittman. Do I understand it that the witness is waiving the attorney-client privilege in this particular instance? I'm a little bit confused, and I want to make sure that I understand and the witness understands what transpires.
He read a statement which I believe he said he was waiving.
No, I'm sorry, Mr. Chairman. There may be some confusion. I'm glad you asked that question, Senator. The attorney-client privilege as to Mr. Bittman and as to me is not being waived.
The counsel, Mr. Sachs and Mr. Hunt, made that statement also, Senator Weicker, in executive session, and agreed to answer certain questions concerning a conversation with Mr. Bittman, reserving the right not to waive all of his relationship in terms of his attorney-client relationship.
Well, I think it's important to point this out, because obviously the chairman and myself were laboring under the same apprehension that possibly there might be a waiver here, and I'm more than delighted to have Counselor state it.
Well, Senator, I think I should supplement what I said by saying that, as the committee knows, Judge Sirica stated that his cooperation with this committee and with the grand juries would be weighed by him in the ultimate sentence which he imposes. Under the force of that statement of Judge Sirica, we have advised Mr. Hunt to answer fully all the questions, but we believe that that does not constitute a waiver as it would in more voluntary circumstances.
I made the statement I had on the basis of this statement on page 5 of his prepared statement. He said, in fact, I have answered all questions, even those which involve confidential communications between my attorneys and myself.
Senator, you have corrected our statement. Our statement was ambiguous. We did not mean all attorneys. There were, the privilege has been waived, as I understand it, with Mr. Jackson and... Excuse me.
Mr. Sachs, would you like to have, or your client like to have recess now instead of waiting on?
I do think, Senator, that my client would appreciate a respite.
Okay.
But just to finish that question, we were a little inaccurate in that statement. I'm sorry. He has waived one privilege, that with Mr. Jackson.
Yes. Well, I would ask you to indicate to the committee if any questions are asked on points that you think he has not waived his right.
Well, he is answering all questions, Senator, but he is stating that by doing that, he is not waiving his privilege.
Mr. Chairman, may I make sure I understand the situation? Just one brief moment. Attorney-client privilege is a personal privilege to the client and not the attorney, and it would apply to each question that's asked. And if this witness chooses to exercise the privilege, he will claim that privilege before answering a specific question. Is that correct, sir? If there is any further concern, if there's any further concern with attorney-client, we will know it at the time the question is asked.
Yes, Senator, but I'm afraid that, to me at least, your question reflects a little confusion. He is not refusing to answer questions as to conversations between him and his counsel, which he normally would do if he were claiming the privilege. At the same time, he is not waiving the privilege.
No, I'm not confused. I don't understand that, but I'm not sure that that's a discernible distinction in the body of the law. Either you claim privilege or you don't claim privilege.
Well, he is answering the questions. I think the issue as to whether his answers constitute a waiver may come up one day if an effort is made to question Mr. Bittman. But this witness is under Judge Sirica's admonition that if he doesn't answer the questions, he's going to be in trouble. So he is answering all questions. He is not claiming privilege as to his answers to questions. But he is not releasing Mr. Bittman.
At some point, Judge Sirica or some other judge will have to pass on the legal effect of those answers.
That is my understanding.
My question to you is, for the purposes of this committee's deliberations, if we are confronted with an attorney-client privilege, we will be notified of it at the time of the question, I presume, by you or by your client.
I take that to mean that if there comes a point in these hearings when Mr. Hunt wants to refuse to answer a question by the committee on the ground of privilege, you would like to be notified.
That is correct.
The answer to that is yes, you will be notified.
I thank you very much.
Thank you.
The committee will stand in recess till 2 o'clock.
As the senators give Mr. Hunt a breather and also recess for lunch, we're also going to pause briefly. Public television coverage of the Senate Watergate hearings will continue after this pause for station identification.
Unabridged coverage of these hearings is being broadcast as a public service by your local public television station. This is PBS, the Public Broadcasting.
NPACT continues its coverage of hearings by the Senate Select Committee on Presidential Campaign Activities. Here again, NPACT correspondent Jim Lehrer.
As we go back to the hearings, Chief Counsel Sam Dash is following up his questions about Hunt's request for money involving his attorney and Charles Colson.
The committee will come to order.
Mr. Sachs, did you want to amplify your remarks concerning the attorney-client privilege?
Mr. Chairman, when we recessed shortly after noon, I was under the impression that the question of Mr. Hunt's waiver of privilege was absolutely clear. But I'm told by those with whom I'm associated that it was not absolutely clear. So I would very briefly like to try to make it clear. Our position, Mr. Hunt's position with regard to the privilege which existed between and exists between him and Mr. Bittman is that Mr. Hunt, under the pressure of Judge Sirica's admonition, has answered and will continue to answer all questions regarding conversations between him and Mr. Bittman, which, because of the privilege, he would not, in my opinion, have to answer. He is going to answer those questions. But at the same time, our position is that by answering these questions, he is not waiving the privilege insofar as any statements or testimony by Mr. Bittman might be concerned. Now, this did come up, as we said, in the Executive Committee session, and I have, during the recess, found the page at which a more lengthy discussion appears, and it is page 452 of the September 20 session.
Yes. Well, your position is very clear. Thank you very much.
Mr. Chairman, I'm terribly sorry to say it isn't quite clear to me still. Is this a fair restatement of your position, then, that as far as the doctrine of attorney-client is concerned, to the extent that Mr. Hunt, for whatever reason, chooses to answer questions that otherwise might be protected by that doctrine, he has waived that doctrine as to himself and the answers he thus makes, but he has not waived it as far as any other statements by Mr. Bittman might be concerned on other subject matter or on that subject matter beyond his statement.
Senator Baker, I would prefer, if you would permit me, not to take the position at this time that by Mr. Hunt's answering questions, he has waived the privilege as to himself. I would prefer to phrase it that he has answered the question without taking the next step and stating as his position the legal conclusion that one might want to argue from.
All right, Mr. Chairman,
I don't think the net effect is any difference between us.
It's not important for the purposes of the committee to resolve that question. As I said earlier on, I suppose if the issue ever arises that a court would have to decide that. We would not. But the point that keeps sticking in my mind, and I want to be clear on, is that we are not precluded from discussing these matters with Mr. Bittman, at least insofar as Mr. Hunt has alluded to.
Well, our position is that you are precluded. That is what we are not waiving. We are not waiving Mr. Hunt's right to maintain the confidentiality of his communications with his lawyer insofar as that lawyer's testimony might be concerned. Now, you may argue, Senator Baker, as you have suggested, or one may argue, that by answering questions as he has, by operation of, as Mr. Hunt has, by operation of law, that privilege has been lost. We recognize that that point may be argued. We will take the opposite position because he has not voluntarily answered the questions concerning his confidential communications with Mr. Bittman. Now, I think since we have gotten into it this far, I really then must make one other point, which does appear in the Executive Committee record, and that is that our office has been in this case a very short time. We were retained sometime during the month of August, and since we were retained, we have had other matters of urgency which have prevented us from devoting full time to this case. We have devoted quite a number of people in our office have devoted a great deal of time to the case, but even so, we certainly, under these circumstances, do not feel are not as acquainted, are not as familiar with the terribly complicated factual situations that surround this case, not sufficiently acquainted with them to be able to advise Mr. Hunt intelligently as to what consequences, if any, might flow from his waiving that privilege. Therefore, our reasoning is that if in that state of inadequate knowledge we were to advise him to waive the privilege, it really wouldn't be competent advice. Therefore, feeling unable so to advise him, we have, on the contrary, advised him not to waive it, and he is following our advice.
Well, Mr. Chairman, I think I'll conclude our colloquy on legal principles and doctrine here by simply saying the underlying reason and rationale for pressing you on that point is to make it clear that as we proceed, first, there may be other questions of Mr. Hunt vis-a-vis his relationship to Mr. Bittman. There may be questions of Mr. Bittman. But I think the very best way to handle this now is to deal with each question one at a time and to see how the doctrine might apply, if at all. Thank you, Mr. Chairman.
Yes.
Speaking for myself, and the committee would have to make up its own mind as to this particular opinion, I would not want this committee to engage in any activity which in effect would force your client, Mr. Sachs, to give up any of his civil liberties or his rights or his privileges, whether those are granted by law or by usage. And I want to make that point clear. Now, it's quite one thing for the committee to vote immunity and handle the question and answer process within certain guidelines which have been well established by the law. It's quite something else to sit here and imply that the committee is being forced to do something that I don't think any committee or court or anyone else in this land has the right to do, which is to take an individual and in effect force him to give up his civil liberties or his rights or his privileges, as I say, whether those matters were granted by law or by usage.
Mr. Chairman, I think the record also should show that when this issue came up in executive session, that I made it very clear to counsel, just as Senator Weicker has just mentioned, that this committee did not want counsel either to advise Mr. Hunt to waive client-attorney privilege or for Mr. Hunt to waive any right that he has solely because he's under a sentencing procedure which might call upon the committee to make a report to Judge Sirica, and that all we wanted was his own statement of the facts based on what he wished to give us, recognizing that there was a fact in history that he is under such a sentencing procedure. But I emphasized over and over again to Mr. Hunt that he should not make any judgment with regard to this committee based on any concept of coercion, but should make the decision voluntarily and based on the advice of his own counsel.
Mr. Chairman, with your permission, I would like to reply to what Senator Weicker and Mr. Dash have said. I don't think any useful purpose would be served at this time in trying to reenact the many conversations or recount the many conversations which have taken place between members of the staff and counsel for Mr. Hunt. Regardless of whether those conversations have included statements from which we might have been entitled to believe that if Mr. Hunt did not waive this privilege, he would receive a bad report to Judge Sirica, regardless of how that factual matter might be resolved. The fact is, and I don't think anyone can dispute this, that at the moment that Mr. Hunt was sentenced by Judge Sirica for a period of more than 30 years, under a provision of the law which gives Judge Sirica the right to amend that sentence, to change the sentence, after receiving reports from prison authorities, Judge Sirica, in a lengthy statement, included a very clear statement that he would weigh, and that was the word he used, the cooperation that Mr. Hunt gave to grand juries in this committee in his final sentence. Now, we think that we have no alternative but to read that as a warning that if Mr. Hunt does not answer all questions, and if he does not waive this privilege, Judge Sirica may say, well, you did not waive your privilege, you did not cooperate, your sentence must be more severe. Now, it is possible, of course, that Judge Sirica would not take that position, but there is very definitely a likelihood, if indeed not a probability, that he will, based on what he has said. So whatever this committee does with regard to articulating the notion that Mr. Hunt should or should not waive his privilege, Mr. Hunt is testifying and has been under that threat.
Also, Mr. Hunt is testifying in a sense involuntarily, because he's testifying pursuant to an order of immunity under statute, which says that the testimony he gives before this committee cannot be used against him elsewhere. And if that statute means what it apparently says, his testimony before this committee cannot be used for any purpose, even to establish an alleged waiver of a privilege, it would seem to me, logically and justly.
With great pleasure, I agree with you, Mr. Chairman.
Well, I want to make one thing clear, speaking for myself and my own questions on this matter, that outside of the grant of immunity, if there is any question that I pose to your client, which question you consider under normal conditions to be violative of your client's rights, but you're permitting this is outside of the grant of immunity, but you're permitting your client to respond because you feel that you're under pressure, I want you to advise me, Counselor, because I don't want the answer.
Senator, I appreciate the expression you've just made, but I'm not really sure that it is possible for me to advise Mr. Hunt within that suggestion. We're talking to Judge Sirica as well as to this committee. We're talking to the judge who is sentencing Mr. Hunt. And I really, with all deference, suggest that you gentlemen really can't help yourselves, but carry out, but by your questioning, but carry out the warning that well, in a way, you can't keep yourselves from holding the sword that Judge Sirica is holding over his head.
But I think it's perfectly possible for your client to go ahead and respond to questions within the grant of immunity, if you will, without going afield and being in the position of violating other rights which he has. And the attorney-client privilege is that type of a situation.
Let me add, please, that by what I have said, I do not mean to suggest that Mr. Hunt is not motivated also to some extent by a desire to do what now appears to be the thing that his country requires. He respects the authority of this committee and its purposes, and he does desire to tell the truth. He is not, I think that makes the point. The only other thing I would have to say, I think, is that here is a 6 or 8 inch pile of transcripts reflecting the questions and answers that have already been made to him and given by him. And it is, of course, possible that questions will be asked today that haven't been asked, but it's fairly unlikely that anything new will be touched on. So while, Senator, you may ask a question and be willing that we not answer it on that basis, the great likelihood is it will already have been asked and answered.
I just have a couple more questions, Mr. Chairman. Mr. Hunt, shortly before your sentence on March 23, 1973, did you meet with Mr. Paul O'Brien in Mr. Bittman's office?
I met with Mr. Paul O'Brien in the law offices of Hogan and Hartson, not specifically in the premises assigned Mr. Bittman.
And can you just very briefly tell us what you told Mr. O'Brien and what Mr. O'Brien told you at that meeting?
I'd be glad to. I believe, Mr. Dash, you're referring to the second meeting I had with Mr. O'Brien.
Yes, just prior to your sentence.
Yes. Mm-hmm. I had requested that Mr. Bittman arrange a meeting between myself and Mr. O'Brien, inasmuch as Mr. Bittman had kept me apprised of the extent of my legal indebtedness to the firm of Hogan and Hartson. Mr. O'Brien, I knew, was the current contact that Mr. Bittman had on the committee, not only for matters relating to the various civil suits that have been filed, but also, and more relevantly, to in connection with the payment of legal fees for Mr. Bittman's services in my behalf. Mr. Bittman indicated to me that his representations for the payment of legal fees had been ineffective, and I suggested to Mr. Bittman that he permit me to speak with Mr. O'Brien about that matter. That is the background of the meeting itself. When Mr. O'Brien came to the offices, we were shown into a private interview room, and I spoke to Mr. O'Brien at some length about the size and nature of the legal bills. I think at that time they amounted to approximately $60,000. I told him at the same time that I was very much concerned about the future of my family, that I would very much like to have the equivalent of 2 years' subsistence available to them before I was incarcerated, that incarceration being due within a very short period of time. And I put it to Mr. O'Brien that I had engaged, as he might or might not know, in other activities which I believe I described as SEME activities for the White House. I don't believe that I specified them. However, I did make reference to them, and the context of such reference was that if anyone was to receive benefits at that time, in view of my long and loyal service, if not hazardous service for the White House, that certainly I should receive priority consideration.
Would Mr. O'Brien be able at least to draw an inference from his part that because of the so-called SEME activities you said that you engaged on behalf of the White House, that if you weren't paid this sum of money, that these may become public?
I'll answer in just one moment. Mr. Dash, in answer to your question, I would have to say that Mr. O'Brien might have assumed any number of things from our colloquy. However, I would, with a great deal of deference and begging the pardon in advance of the chairman of the committee, quote from a certain testimony given in the early sessions of this committee, the first green-bound volume, page 325, when Mr. Alt was being questioned. And Mr. Irvin, Senator Irvin, said, and I quote, "Well, where two men communicate with each other by word of mouth, isn't there a twofold hazard in that communication in, first, that the man who speaks may not express himself clearly, may not say exactly what is in his mind, and if he does, the man who hears it may put a different interpretation on the words than the man who spoke them," unquote.
Well, Mr. Hunt, there has been considerable testimony, which we will not get into now before the committee, which indicated that both Mr. Dean and Mr. Mitchell and a number of others believed that there was considerable pressure being placed by you at that time for money, and that the danger of not paying you was that there might be some public exposure of the Simi matter. In fact, Mr. Ehrlichman testified that there was a blackmail threat. So the question put to you was, did you intend, by telling Mr. O'Brien that one, the $60,000 had to be paid, and two, you had engaged in certain other Simi matters on behalf of the White House, did you intend to create that threat that unless that money was paid, you would make public the acts that you had engaged on behalf of the White House?
No, sir.
Now, how did Mr. O'Brien respond to you when you asked for this money?
Well, it was more than simply a question of asking for money, Mr. Dash. It was really my first opportunity to catalog the many difficulties that we had had, that is to say my late wife principally, and to some extent myself, in finding the means to defend ourselves that had been promised us as long ago as the previous June 21st. I told, Mr. O'Brien told me, I should say, that he was finding himself increasingly ineffective as a go-between. I don't recall whether he used the word impotent or impotence, but he felt that his position was a very difficult one. He recognized that assurances had been given, that to some extent they had in the past been carried out, but he felt that he was becoming less and less effective as an intermediary.
Did he mention Mr. Colson to you?
For that reason, Mr. O'Brien suggested that I originate and send to Mr. Colson what he termed a strongly worded memorandum, or a tough or a hard memorandum to Mr. Colson.
And what did you do after that? Did you write such a memorandum to Mr. Colson?
I did not write the memorandum to Mr. Colson, but in response to Mr. O'Brien's suggestion, I believe that orally I expressed surprise that he would have brought Mr. Colson's name into the dealings at this late stage of the game. I asked him why he wanted me to send the memorandum to Colson. And Mr. O'Brien said, to the best of my recollection, well, there are some of us who feel that Chuck stayed out of this too long, that it's time he got his feet wet along with the rest of us, words to that effect. My response was equivocal. I did not indicate to Mr. O'Brien whether I would or would not address such a memorandum, but I was disturbed by his suggestion.
All right, now, after that meeting with Mr. O'Brien, did you take steps to either try to have a meeting with Mr. Colson, to write to Mr. Colson? What efforts did you make to follow up on Mr. O'Brien's suggestion?
Excuse me. I reviewed at once for Mr. Bittman, upon Mr. O'Brien's departure, the substance and thrust of Mr. O'Brien's conversation. I told Mr. Bittman that I had no intention of writing the recommended memorandum, but I thought that I should get in touch with Mr. Colson so that I could explain the situation to him, notify him of the suggestion that had been made by O'Brien, whom I classified, politically speaking, as a Mitchell man. And we haven't gotten into this in testimony so far before this committee, but there appeared to be a definite division within the White House itself, at least in the lower levels, between the so-called Mitchell men and the so-called Colson men. Accordingly, I found it rather bizarre that Mr. O'Brien, a Mitchell man, would suggest that I seek help from Colson, inasmuch as Mr. Mitchell had been the progenitor of the Gemstone plan and was at least in theory, responsible for seeing that the assurances that were implicit and explicit in Gemstone were carried out. Mr. Bittman, to my knowledge, did get in touch with the office of the law offices, for by then Mr. Colson was in private practice, with the law offices of Colson and Shapiro, and made these representations in my behalf, i.e. that I desired a meeting with Mr. Colson. A day or so later, I was informed by Mr. Bittman that although Mr. Colson would not see me, his partner, David Shapiro, would see me, and he would see me the following Friday, I believe the 16th of February, early in the afternoon.
And did you have that meeting with Mr. Shapiro?
I did.
And did you tell Mr. Shapiro substantially the same things that you told Mr. O'Brien?
I did.
Including the other activities that you engaged in on behalf of the White House?
I did not specify them. I referred to them. I might add that the context of our meeting was entirely different. Whereas Mr. O'Brien had approached me, I might say almost apologetically, Mr. Shapiro approached me rather aggressively and subjected me to a lengthy monologue, which I consider to be highly self-serving. My response was that I had expected actually to see Colson, although I could understand that for purposes of record, they might want it to appear that I had met only with Shapiro rather than with Colson. I had not really expected to be received by a Colson surrogate.
Now, did you make it clear to Mr. Shapiro and Mr. O'Brien that you needed to get the money prior to the date of sentence?
Yes, that if I
Why was that?
That I was to make, if it was to be of any assistance to me in terms of making prudent distribution of it among the members of my family, my dependents, taking care of insurance premiums and that sort of thing, that would have to be delivered to me before I was in jail. This was not only implicit but explicit as well, Mr. Dash.
Now, what did Mr. Shapiro say to you when you made those representations to him?
He indicated to me that he would use his own discretion as regards such portions of my conversation as he chose to convey to Mr. Colson. I responded rather angrily that I felt that he should convey all of what I had to say to Mr. Colson.
But despite what you consider to be an unsatisfactory reception by Mr. O'Brien and Mr. Shapiro, you in fact did receive a large sum of money prior to being sentenced. Is that not true?
Yes.
And how much did you receive?
$75,000.
And you remember when you received that? Would it refresh your recollection if the record would show that you received it on March 20th?
I would have said 20th or 21st. If the record shows the 20th, that's perfectly satisfactory.
Just a couple days before the sentence?
Yes, sir.
And what did you do with that money, Mr. Hunt?
I put it in the safe deposit box.
And did you pay
eventually?
And did you eventually pay Mr. Bittman some of that money?
No.
Did you pay Mr. Bittman any money out of that sum?
I paid Mr. Bittman $60,000 that derived from the proceeds of my late wife's insurance policies.
I have no further questions, Mr. Chairman.
Good. May I have the indulgence of the committee for just 1 second?
Scott just gave it.
Mr. Sachs, it has been suggested to me that I may have misspoken a moment or so ago, in which case I want the record to reflect that I did, in fact, inform Mr. O'Brien of the fact that I had taken part in other SEME activities in behalf of the White House. I hope the record is clear in this. I don't believe that I specified to Mr. O'Brien what they were. However, I made a generic reference to them. Is there any question on this?
Your response was clear. By the way, that $75,000 you received just before you were sentenced, in what manner did it come? Do you know how you received it?
Yes, sir. It came in an unopened envelope that was handed me by Mr. William Bittman.
And did he indicate to you how he received it?
Yes, he did.
Can you tell us what he said?
I received a telephone call from him at my residence indicating that he had received telephonic notification that an envelope would be left in his mailbox for me at a certain time. He inspected his mailbox following that particular time, found an envelope there, and telephoned me. I then went to his home, which is a short distance from my own residence, and received the envelope from him.
I have no further questions at this time, Mr. Chairman.
Mr. Hunt, you state in your opening statement that, in your opinion, the Watergate break-in was an unfortunate use of executive power. What executive power are you referring to?
I'm referring to the power delegated to the Attorney General of the United States by the President of the United States.
Who involved in the Watergate break-in or the planning of the break-in had that power, in your opinion?
Well, we're referring to the Watergate break-in solely?
Yes, sir. Your statement refers to the Watergate break-in solely, I believe.
The Watergate break-in was a part of the Gemstone operation, an integral part of the Gemstone operation. It was financed out of Gemstone funds. Gemstone personnel accomplished it. The concept, as I understood it from Mr. Liddy, and again I must be very clear that this was hearsay information, that the project, the program, if you will, had been conceived, proposed, and engendered by the Attorney General of the United States with the assistance of the counsel to the President, Mr. John W. Dean III, and with a former and very recent White House aide, Mr. Jeb Stuart Magruder. The proposal had been put to me at the time by Mr. Gordon Liddy, who was a full-time White House employee and with whom I had worked in the fielding and other operations.
Did you consider the Watergate break-in then a legitimate governmental operation?
Excuse me. In the context in which the break-in requirement was levied on me, I did, yes, sir.
What context was that?
Was that foreign monies were reported to be to have been sent or received by the Democratic National Committee.
And when was that information related to you?
In April of 1972.
April of 1972?
Yes, sir.
Have the Watergate plan, to your satisfaction, been approved prior or subsequent to that time?
The actual Watergate break-in was not approved. That aspect of the Gemstone program was not approved until the time coincident with my receipt of the information concerning the report having to do with the receipt by the Democratic National Committee or the probable receipt of foreign monies.
But the discussion about the Gemstone plan had been taking place prior to that time, had it not, according to your information?
Beginning in November of the prior year.
When did you, in your mind, when did you agree to become a part of that plan?
Could you specify what plan? Do you mean the Gemstone or the Watergate?
The Gemstone plan.
almost as soon as Mr. Liddy made the proposal to me, he having invoked the names of the Attorney General and Mr. Dean at that juncture.
That would have been in December of
Late November, I would
1971,
say.
late November.
Yes, sir. I had no hesitation in associating myself with the operation.
Let's see. And when did it first come to your attention that the Democratic National Committee headquarters were going to be broken into?
Not until April of the following year.
Was this before or after you were informed that foreign money was coming into the DNC?
Not until... Perhaps I misunderstand you, Senator. The Watergate break-in did not...
I'm not a senator.
I beg your pardon,
Thank you
Mr.
anyway.
Thompson. Excuse me, sir. We did not begin to formulate plans for the Watergate break-in until after reception of the report to the effect that foreign monies were being received by the Democratic National Committee.
But a plan was underway which included the possibility of surreptitious entry before that time.
Yes, sir.
And you associated with that plan on the authority, in your mind, of the Attorney General, although you did not know the specifics at that particular time as to why he was authorized to set up such a plan in motion. What I'm getting at, Mr. Hunt, is I wonder what was in your mind at that time as to what the Attorney General could do and could not do. Surely anything that he decided to do would not necessarily be a legitimate activity, whether or not the President went along with it. I'm wondering what justification you had in your mind for subscribing to a plan which was designed toward an opposition party in an election year.
I can really say only this, Mr. Thompson. And having spent 21 years in CIA, following orders without question, and a prior 5 years with the Armed Services, following orders without question, it never occurred to me to question the, if you will, the legality, the propriety of anything that might be ordered by the Attorney General of the United States.
And you took Mr. Liddy's word for that?
I did.
The other activities that you were engaging in during the period of time that you worked in the White House, I believe you mentioned, of course, the entire Ellsberg situation, which I believe you say was a matter of national security at that time. The Greenspun situation, the information that you understood you might have had on Senator Muskie. I believe the overall Gemstone plan also included perhaps a airplane surveillance of opposition planes or something of that nature, did it not?
It did at one point, yes, sir. May I specify that anything having to do with electronics was drawn up by Mr. Liddy in conjunction with a specialist whom I later came to know as Mr. McCord. I had nothing to do with that budget.
All right. Also, your activities included the convention situation that you referred to, getting people, recruiting people down there in a political context. I'm just wondering when, if the foreign money situation was the only thing outside of the purely political context that came to your attention as a justification for the Gemstone operation.
I was never given any other.
All right. Who told you?
Excuse me just one minute.
Who told you that foreign money was coming into the DNC?
Mr. Liddy.
Where did he get his information?
I believe that he was receiving it from a government agency.
From a government agency?
Yes, sir.
Did he specify which agency?
No, sir.
Did you have an opinion as to which agency?
Yes, sir.
What was your opinion?
My opinion was that it came from the FBI.
Did you have any independent corroboration of that assertion?
No, sir.
Did you make any inquiry?
No, sir.
Do you believe that... believe, do you remember whether or not he told you the particular agency, or you just concluded that in your own mind? Did he tell you that it was an agency, or did you conclude that in your own mind?
I would go back to our mutual experience in the Plumbers Organization, at which time we were receiving daily reports from most of the investigative agencies of the government with relation to the Ellsberg case. Mr. Liddy had, on the basis of prior associations in the FBI, a private channel, a person or persons who would telephone him or send him memoranda from time to time, providing him with information which was not distributed generally within the White House. That is to say, there were really two channels reporting from the FBI into the White House. There was the J. Edgar Hoover channel to, let us say, Mr. Ehrlichman and Mr. Krogh. We would see copies of those memoranda. There were also materials that were coming to Mr. Liddy from Mr. Mardian in the Justice Department, and I believe telephonic information that came to Mr. Liddy from close and old-time associates of his at the FBI. So I had every reason to believe that he was still well plugged into the Bureau.
Did he tell you precisely the source of these foreign monies, the country?
Yes, sir.
The individual? What did he tell you?
Cuba.
What would be the normal procedure with regard to investigating a matter like that if any organization in this country was receiving money from a foreign country, especially a communist country?
The practice normally would be to lay a requirement on the CIA abroad and the FBI at home. However, the President had established the Plumbers Unit because certain traditional agencies of the government had been deemed inadequate in the performance of their duties.
Was the Plumbers Unit in any way operative in April of 1972?
Yes, indeed.
You know whether or not they were looking into this matter?
No, sir.
You don't know whether or not they were?
I'm quite sure they were not.
Nobody else was, as far as you know?
No, sir.
With regard to the actual scene, who was in charge of the various operations on the night of the break-in, the early morning hours of June 17, 1972?
The responsibilities were the same as they were during the prior break-in on May 27th. That is to say, I was in overall charge of the entry operation. I planned it, and with Mr. McCord's help, surveyed the groundwork, developed the operational plan. Mr. McCord had certain electronic responsibilities, the precise nature of which I was unaware of. My team, that is to say, the foremen from Miami, were charged with photographing documents that would bear on the object of our search, while Mr. McCord went about his electronic business.
Did you tell any of the Cuban Americans about the foreign money information that you had?
I did.
Who did you tell?
I told Mr. Barker, and this was the basis on which I secured his cooperation initially.
Do you know whether or not he related this to the people he enlisted to assist him in the operation?
I believe he may have. If I can amplify a bit, Mr. Thompson, when I approached Mr. Barker with the requirement for an entry into Democratic National Headquarters, I told him that we wanted to verify a report to the effect that Castro money was reaching Democratic National Committee coffers. And Mr. Barker's immediate response was, that rumor is all over Miami. I've heard all about it. You don't need to tell me anything more.
Did you tell him anything more about it?
I knew nothing more about it.
And did he operate then on your information?
He did.
Was there any financial reward in any way for Mr. Barker or any of the other Cuban Americans out of the Watergate break-in?
There was compensation for them for time lost from their normal businesses, yes.
But was there anything additional to that?
Not that I know of, no, sir.
What about the break-in of Dr. Fielding's office? Was there any pecuniary benefit coming out of that for them other than just expenses, time, or money for time lost from work, that sort of thing?
No, sir, that was all.
What was told the Cubans with regard to that operation, with regard to the break-in of Dr. Fielding's office, the reason, the necessity for it?
I told Mr. Barker originally in Miami that a break-in would be necessary, an entry operation would be necessary on the West Coast, as we had information to the effect that a man whom I believe I described as a traitor to the United States was passing classified information to a foreign power.
Were you the one who enlisted Mr. Barker's aid to come to Washington during Mr. Hoover's funeral?
I was.
Did he in turn enlist the aid of other Cuban Americans to come with him?
He did.
And what was the reason for your arrangement with them to come to Washington?
This was in response to an urgent requirement by Mr. Liddy, who indicated to me that he had information, again I assume this to be from a U.S. government agency, to the effect that in conjunction with a peacenik demonstration on Capitol Hill premises, that an effort would probably be made to desecrate the catafalque of J. Edgar Hoover, who was then lying in state here in the rotunda of the Capitol. It was desired that perhaps as many as 10 or a dozen men be brought up from Miami so that they could circulate through the crowd, sense their temper, and if a surge was made from the focus of the demonstration then in progress, that these men could interpose themselves around the casket of J. Edgar Hoover and prevent its desecration.
Did they...
Further, that if a Viet Cong flag was unfurled by the demonstrators, who included such notables as Messrs. Kunstler and Ellsberg, Jane Fonda, the Sutherland, and so forth, that that flag be obtained, taken from them, and turned over to Mr. Liddy.
Did they come?
They did.
Did they subsequently engage, I believe, in fisticuffs with some of the demonstrators there?
I've heard that alleged.
Did they receive any financial reward or benefit out of that operation except for their expenses coming and going?
Not to my knowledge.
With regard to the Fielding break-in and the DNC break-in, as far as you know, their motivation was, first of all, that they were doing something to expose a traitor, and secondly, that they were trying to uncover or verify reports that Castro money was coming into Democratic National Committee headquarters.
Yes,
as far
sir.
as you know, that's the sole basis of their action.
Yes, sir, although there was speculation, of course, that Hanoi money might be coming in as well.
That what?
There was some speculation among us that money from Hanoi might also be coming in as well, but this was not part of the corpus of Mr. Liddy's representations to me.
Who told you that?
Nobody told it to me, Mr. Thompson. Senator McGovern, though, for some time had been saying that he would, in effect, call to Hanoi if it meant the release of our prisoners. And we felt that if Castro money might be coming into Democratic National Committee coffers, that money might also be coming from Hanoi as well.
Did you tell Mr. Barker to look for any particular kinds of documents when he entered the DNC that night?
Yes, sir.
What did you tell him to look for?
Financial documents, ledgers, account books, that sort of thing.
Would Mr. Barker know if he came across significant documents in this regard, do you think? Did he have any background in political campaigns or finances?
My presumption, or our operational presumption was, Mr. Thompson, that during the course of his search, Mr. Barker would come across ledgers and account books of some kinds, all political parties being required to keep them. His instructions were to photograph, in effect, any page with a figure on it, later on a determination would be made as to the significance and validity of those figures, sources of the funds and contributions.
We've heard testimony about how the entry was carried out that night. I believe that we've heard testimony about how the entry was carried out that night. And you correct me if I misstated. I believe Mr. McCord first taped the locks on the door and returned, found that the tape had been removed. And then there was a discussion among the people there as to whether or not entry would be made after finding that situation there. Do you recall such a discussion among yourself, Mr. Lady McCord, and the Cubans?
Yes, sir.
Relate that discussion to us as best you can remember.
Mr. McCord came up to room 214 where we were waiting. I'm speaking now of the Watergate Hotel, and said that he had previously taped the locks on the entry door in the basement of the Watergate office building. He said that on returning just prior to the meeting that was then in progress, he had noticed that the tape had been removed and he had retaped the door. I asked him why he had done that, and he said that he had noticed a large pile of mail sacks in the vicinity, and he felt that the mailman, on exiting the Watergate office building premises, had taken off the tape.
That he told you that he had already retaped the door at the time?
I had retaped the door, yes. At that point, I said, let's junk it, meaning let's scratch the operation. Mr. Liddy and Mr. McCord talked between themselves, and the decision was made to go.
Did you hear the conversation between Liddy and McCord?
I walked away. As I recall, I walked over to the window. I thought that it was very foolhardy to proceed on that basis. I might add that I had argued for 3 days in advance ineffectively with Mr. Liddy prior to the 17th of June against a second entry into Watergate.
Why?
Because it had been known to me through reports Mr. McCord had made that Mr. O'Brien was no longer in residence there, and that there was evidently a large-scale movement of books, files, call it what you will, from the Watergate office to the convention headquarters of the Democrats in Miami. I felt that in effect, the bird had flown.
Did you hear any of the conversation as to who made the final decision, or who was for or against re-entry?
I think it was a mutual decision, a common decision between Mr. Liddy and Mr. McCord.
Mr. McCord gave what reason in his mind for the tape having been removed, as to who removed it?
That he had seen immediately adjacent to that door a pile of large mail sacks, which he felt had been collected by the mailman. And on exiting the building, the mailman must have noticed that the lock was taped and had removed the tape. And Mr. McCord was convinced, he told us, that it was just happenstance. He thereupon retaped the lock, came up to our room, and said, in effect, I'm ready to go, let's go.
How did he get the door back open to retape it?
I don't know.
Was there any discussion about buying off a guard, perhaps?
No, sir. But there was money available for that.
Do you know why that was not carried out?
No, sir. I don't believe that it hadn't been necessary in our first entry. We didn't even attempt it the second time around.
Did you know at the time that some of the people who were going to make the entry were carrying $100 bills on them in numerical sequence that could be traced?
I don't think I knew that they were carrying sequential bills on them, no, sir.
Was any check made of things of that nature as to what was on the persons of the people making the entry, and what would be done, or what would happen?
They were told to take their personal wallets, billfolds and so forth, and put them or leave them behind in room 214, which I believe they did. They were then provided, a couple of them were provided with false documentation, which I had received from the Central Intelligence Agency. We felt the flash documentation plus the money that they had on them would be sufficient to get them out of a local guard-type situation.
After the break-in, did you have occasion to call Mr. McCord and talk to him about Mr. Baldwin?
I did.
His hiring of Mr. Baldwin?
Yes, sir, I did.
Did you relate that conversation?
At about the time that Mr. Baldwin began telling his story to the Los Angeles Times.
When was that? How long after the break-in would you say?
May I consult my
Yes,
notes? Should be a matter of record. Mr. Thompson, I would have to place it as a guess sometime toward mid-July or even late July, at a time when Mr. McCord was no longer in the District of Columbia jail, and at a time when Mr. Baldwin had begun, so to speak, to sing.
All right. Would you relate the conversation?
I was quite disturbed by the revelations that Mr. Baldwin was making. I telephoned Mr. McCord and asked him to explain, in effect, the circumstances surrounding this errant disloyalty on the part of a man he had hired. Mr. McCord said that he himself, Mr. McCord, was short on funds. I suggested that he sell a van, which Mr. Baldwin had, for some reason, driven to Mr. McCord's home in the wake of the operation against my instructions to take it elsewhere.
Pardon me, did you say against your instructions?
Yes. Following the break-in, I probably should go back to clarify the record in a very minor way. I had been asked before the lunch break to recount my own movements following the Watergate, the arrest of the 5 men. I did not go directly to the White House. I went over to the Howard Johnson Motel and spoke with a man whom I had not previously seen or met, but whom I knew to be an employee of Mr. McCord's, and told him to load all of his equipment into the van that McCord had and to drive away, get away from the premises. He said, "Where shall I go? Shall I take it to McCord's home?" I said, "No, any place but that. I don't care where you take it. Drive it into the river. I don't care." In any event, as it developed, Mr. McCord took the van, Mr. Baldwin took the van to Mr. McCord's house and left it there.
You know how far his house was from the Howard Johnson's hotel? Was it close by?
Mr. McCord's house?
Yes.
No, it was a substantial drive. I would guess 15 to 16 miles, if not more.
All right. Go ahead. You were talking about your conversation. If that's all you have to relate on that.
Yes, sir.
You pick up your conversation with Mr. McCord now about that.
Yes. So I was rather critical of Mr. McCord for the performance of his employee, and Mr. McCord, on his part, was rather defensive. He indicated to me that in the wake of the arrests that Baldwin had felt himself abandoned and had gone directly to the Committee for the Re-election of the President to seek instructions and or financial assistance, and he had been rebuffed. Feeling himself thus abandoned and cast upon his own resources, I am again quoting Mr. McCord to the best of my recollection. Mr. Baldwin sought counsel in Connecticut and retained 2 attorneys who, in whose hands he subsequently remained. And it was on the basis of their advice that he began giving interviews, the first of which was, I believe, the Los Angeles Times.
Was that the only conversation you had with Mr. McCord about Baldwin?
To the best of my recollection, yes, sir.
All right. You didn't know Baldwin except through McCord, I take it.
I saw him 2:30 odd hours the morning of June 17th in a darkened room. I would never have been able to identify him except through the photograph that I saw in the newspaper.
All right. Mr. Hunt, you've been asked this morning about what, in your opinion, Mr. Colson knew about an overall plan or a Gemstone plan, and I'm not sure that I have that straight in my mind. You refer, first of all, to a conversation you had with Mr. Colson in January, I believe, of this year, when you, of 1972, when you told him that you were, in effect, going to the committee to re-elect. Then we referred to a conversation you had with Liddy after the meeting that you had with Liddy and Colson in Colson's office, when Mr. Liddy said that he thought Colson would help. Now, just what, in your opinion, did Mr. Colson know? First, just what, in your opinion, did Mr. Colson know about the Gemstone operation, and what is the basis of that opinion?
Would you excuse me a moment? To address myself to your question, Mr. Thompson, and I'm reading from some notes that I've compiled. Is that permissible?
Yes, sir. When did you compile it?
Within the past 10 days.
Was it before or after the grand jury session when you first related to the staff the fact that, in your opinion, Mr. Colson did know about the Gemstone operation?
It was in connection with that.
Was it before?
Mr. Thompson, that was not a grand jury session.
I'm sorry.
You said grand jury.
Executive session with the staff. You recall whether it was before or after that session?
It was at the same time.
Well, it couldn't have been exactly the same time, could it?
In order to make my presentation to the committee in executive session, I prepared the notes that I am now requesting permission to read.
Had this question or a similar question that I just posed to you concerning his knowledge been posed to you in executive session before you made these notes?
Yes, sir.
All right, go ahead.
In late January 1972, I told Colson that as a result of my increasing involvement with Gordon Liddy, I would be unable to give anything like as much time to Colson as I had in the past. Colson said, "That's all right, you can be a lot more useful over there," i.e. working for Liddy. I remarked that he was probably aware of the large-scale intelligence program that had been conceived and which Mr. Liddy was heading. Colson said, "I'd have much preferred that you head it." He indicated at the same time that he had already provided bona fides on my part to Mr. Mitchell. I replied that I liked the arrangement with Liddy, that I had worked with and had full confidence in Liddy. At the same time, I had a rather demanding job at Mullen & Company. And I told Colson that I would like to be able to be available to him, Colson, within the limits of my physical capacities, and said that I assumed I would maintain my White House office in safe. Colson said that was no problem. This is the background for Colson's perceptions when I called on him with Liddy about a month later. Colson knew that I had been engaged in covert activities with Liddy. He, in fact, I've been given to understand, actually financed the fielding entry.
When did you learn that?
I learned that in conjunction with an appearance I made before the Watergate grand jury.
You were told that at that time?
Yes.
By financing the fielding entry, of what could you be a little bit more specific as to actually what they told you he did?
That he provided the monies which were used by Mr. Liddy for that purpose.
Were you told who he gave the money to?
I'm sorry, sir.
Were you told who he gave the money directly to?
Who was he?
Mr. Colson.
Well, I have testified that I saw Mr. Krogh give money to Mr. Liddy, but it was not until recently that I learned that Mr. Krogh received the money apparently from the hands of Mr. Colson.
And you don't know anything about the circumstances of his giving money to Krogh, I assume?
No, sir, I do not.
He gave the money to him?
No, sir.
All right.
I do not.
Go ahead.
Colson also acknowledged that he was aware of a plan conceived by the Attorney General to secure intelligence on radical groups and Democratic candidates, that being the Gemstone program, and that I was working on this with Liddy as a covert collaborator.
This was in January, the January meeting?
Yes, sir, the January meeting.
So we actually said, you used the word Gemstone.
No, sir.
Would you read that last portion again?
I was not reading, I was interpolating.
I see. What exactly did he say, other than what you've already related? I believe in response to your inquiry as to whether or not he was aware of a large-scale intelligence plan, he said, I'd rather you hit it.
This was my summation of the conversation. I had said earlier, I remarked to Mr. Colson that he was probably aware of the large-scale intelligence program that had been conceived and which Mr. Liddy was heading. He said that he was, and in fact that he had checked my bona fides on behalf of the Attorney General.
All right. When did you conclude in your own mind that he was, in fact, aware of it? As soon as he said it in that meeting?
Yes.
All right. What about the meeting in February after you left? I believe you had a conversation with Mr. Liddy, and if my memory serves me correctly, I believe in executive session you said something to the effect that that was the first time that you really became aware, or you concluded in your own mind that Colson must have been aware of exactly what was going on with regard to the Gemstone plan.
I said that, Mr. Thompson, at an early session of the executive, an early executive session. However, subsequently, due to a different line of questioning by counsel to this committee, I was able to reconstruct events that had not, at that point, been fresh in my mind.
Let's see if this is the line that you're referring to. I'm referring to the transcript, September 20, 1973, Thursday. I'll start reading at line 11. It's in late January.
What page, Mr. Thompson?
Sorry, page 467. Start reading about line 11, and I'll be skipping some. If you want to take the time to read the part in between, of course, that's perfectly all right. In late January 1972, I told Charles Colson that as a result of my increasing involvement with Gordon Liddy, I'd be unable to give him anything like as much time to Colson as I had in the past. He said, that's all right. You can be a lot more useful over there. That is to say, working for or with Liddy. I remarked that he, Colson, was probably aware of the large-scale intelligence program that had been conceived, which Mr. Liddy was heading. Colson said I would have much preferred that you had it. I replied that I liked the arrangement. I had worked with and had confidence in Liddy. Besides, I had full-time work with Mullen and Company. I told Colson I would continue to be available to him within the limits of my time. I assumed I would maintain my White House office and safe. Colson said this would be no problem. And then, if I may,
like to move over to page 471. Is that a vote? Recess.
That is a vote signal, and so we'll have to take a temporary recess till we can get over there and vote.
The senators now go to the Senate floor for a vote on a military aid bill, and as they do that, we're going to pause briefly. Public television's coverage of the Senate Watergate hearings will continue after this pause for station identification.
Unabridged coverage of these hearings is being broadcast as a public service by your local public television station. This is PBS, the Public Broadcasting.
From Washington, NPACT continues its coverage of hearings by the Senate Select Committee on Presidential Campaign Activities. Here again, NPACT correspondent Jim Lehrer.
As we go back to the hearings, Howard Hunt is being questioned by Minority Counsel Fred Thompson.
My name is Fern, Maria, M-A-R-J-A.
The committee will come to order.
Mr. Hunt, without reading on, let me see if I can summarize the situation. You correct me if I'm wrong. I got the impression from reading the transcript that the question was posed to you as to how could it be that that you would be brought, that such a conversation could come about between Mr. Liddy and Mr. Colson. What would be a plausible explanation for that, and possibly your being there, and what kind of an explanation would be plausible with regard to what Mr. Liddy told you afterwards? And you, in effect, concluded that, well, the only plausible explanation would be that Mr. Colson must have known about it beforehand. Would that be a fair summary of what you stated in executive session?
Yes, sir.
Well, if that's the case, then that would indicate that it was after the February meeting that you concluded in your own mind, anyway, that Mr. Colson was aware of the Gemstone plan, and not before that time. I got the impression that you were saying that after the February meeting was the first time you realized in your own minds, when it struck you, Mr. Colson must have been aware of the overall plan.
At that time, yes, sir.
Well, then when you had the January meeting with Mr. Colson and you discussed the reasons for going to the committee to re-elect, I assume that you did not come away from that discussion with a feeling that he had an awareness of the overall Gemstone plan?
I'm sorry, Mr. Thompson, but I couldn't tell if you said awareness or unawareness, so I missed that question.
Awareness.
Is the question clear to you?
I believe I'm having difficulty now in discriminating between questions, Mr. Thompson. I'm terribly sorry. I'm not trying to be obstructive. I want to be responsive. Could you restate the question as it stands?
Let me put the question to you just the way it was put in executive session then, Mr. Hunt. I've already related where you stated that you had a conversation in January with Mr. Colson about the overall intelligence plan. Mr. Dash asked you, other than the particular intelligence plan that you were working with Mr. Liddy, on which Mr. Liddy was getting approval from Mr. Mitchell, which is known as, we know now, the Gemstone plan. Was there any other plan in effect? Mr. Hunt, no, sir. Mr. Dash, so in restating it, the Gemstone plan was the only large-scale intelligence plan which was in existence at the time. So Mr. Colson's statement to you that he was aware of this plan could only refer to the Gemstone plan. Yes, sir. And that is what led you to believe that when you, in February, introduced Mr. Liddy to Mr. Colson, that Mr. Liddy, on his own, while you were there in the rear of the room, urged Colson's assistant on this plan, that Mr. Colson was already aware of the Gemstone plan, did not need any further information provided by you, person he would entrust, and this would be the basis upon which he made the telephone call to Mr. Magruder.
Mr. Thompson, I'm sorry, but we don't have the page, and we're not following. It's going a little too fast. If you will direct us to the page.
I'm reading from pages 471 and 472.
I think our problem is that Mr. Hunt doesn't quite know what the question is.
When did you first become aware in your own mind that Mr. Colson knew about the Gemstone plant?
In January.
In January?
Yes, sir.
All right. Now, Mr. Dash has referred to an executive session on May the 14th, 1973. Would it be fair to say that this executive session, the statement which he referred to, where he questioned you as follows, Mr. Dash, actually, when did you first learn from Mr. Liddy that the sign was okay, the go sign, referring to the approval by the Attorney General? Well, I would put it very late in March, very late in February, if not in early March. Mr. Dash, now it was around that time that you met with Mr. McCord in March. Yes, sir. During that time, did you ever indicate in the presence of Mr. McCord that these plans would have, that you were in touch with other persons yourself in the White House, Mr. Colson, or anybody else concerning these plans? No, sir. Mr. Hunt, no, sir. I would not have done this because it was true to the best of my knowledge. Mr. Colson had no specific knowledge. He had no knowledge of my dealings with Mr. Liddy from me. Now, if Mr. Colson had collateral knowledge or awareness, he did not confide in me. Mr. Dash, besides these people who were meeting, and that would be Mr. Mitchell, Mr. Dean, Mr. Magruder, and yourself, and the Cubans who came up for that, who else, to your knowledge, was aware of this activity? Mr. Hunt, of the overall project? Mr. Dash, yes. Mr. Hunt, I have no personal knowledge of anyone. Would you say that that is inconsistent with your present testimony?
Yes, sir, Mr. Thompson, and let me try to reconcile this as best I can, as I believe I have in subsequent testimony. That until a matter of some 2 weeks ago, perhaps less, it had been my firm conviction that there had been no substantive knowledge on the part of Mr. Colson concerning the Gemstone or the overall intelligence plan. However, following a line of questioning embarked upon by Mr. Dash, a train of thought was sparked which led to my recollection of the January meeting with Mr. Colson, which then became significant to me. On that, the basis of my reconstruction of our January meeting, I was able to postulate what Mr. Colson's perceptions might have been during his meeting with Liddy and myself in February. And it is to that I have given my most recent testimony.
So you, in effect, did not remember up until the time Mr. Dash embarked upon that line of questions?
That is correct.
That you had discussed this matter in January with Mr. Colson, and he indicated he was aware of it?
That is correct.
Would you not consider that a significant piece of information?
I consider it a piece of significant information now, yes, sir.
Well,
in January, I was not acutely conscious of it in terms of significance.
Or did you realize the significance of it on May the 14th when you stated that, as far as you know, Mr. Colson or no one else had knowledge of the plan?
On May 14th, I did not recollect it, Mr. Thompson.
Since May 14th and your testimony here and the testimony in the executive session where this was brought out, you have filed a motion, I believe, to set your pleading aside, to set your plea of guilty aside, I believe. Have you not?
Yes, sir.
And if I understand it, that motion is based in part upon what you might say executive approval of some kind of the plan, which would justify the plan, at least in your mind at that time. And you mentioned Mr. Dean, you mentioned Mr. Magruder, Mr. Mitchell, I believe, and also Mr. Colson in your pleadings with regard to your motion that you filed to set your plea aside. Is that correct?
Yes, sir. With all deference, Mr. Thompson, let me point out that Mr. Dash has previously asked me, in effect, the same question, and I have responded, I believe, and the record will show, that my plea is not based substantively upon Mr. Colson's involvement or non-involvement.
Well, my failure to understand was based upon what I understood your original testimony to be, that this was
this latest information in response to Mr. Dash was additional information, but was not inconsistent. Now, as I understand, you say that it is inconsistent, but it's based upon your failure to previously remember. I'd also like to ask you concerning a letter which you wrote Mr. Colson on August 9, which I'd like to furnish you a copy of if you, at the present time, if you don't have. I have copies. Give a copy to Sam. It already is an exhibit. This was furnished to us. This is an exhibit, part of the record. This was furnished to us by Mr. Colson, I believe. It's a letter to Colson dated August 9, 1972. In the first part of it, I won't go into it unless you care to. It has to do with the fact that you were removed from Mullen's HEW account. In the last paragraph, you say, "Let me say, I profoundly regret your being dragged into the case through association with me, superficial and occasional though the association was. What small satisfaction I can dredge up at the moment is the knowledge that I was not responsible for the affair, its outcome. All this pales, of course, besides the overwhelming importance of re-electing the president, and you may be confident that I will do all that's required toward that end." Was it your opinion at that time that Mr. Colson was being dragged into the case solely because of his prior friendship with you, or do you now feel like that he was possibly being dragged in because he knew of the plan from the very inception?
Because of his what with me, sir?
Because he knew of the Gemstone plan, perhaps in some way participated in it.
He was being dragged into the Watergate case by the press because he had been my sponsor in the White House, and because one of my alternate telephone extensions was out of his office. That was how the connection had initially been established. I regretted that.
So that was the sole basis that you had, as far in your mind at that time, for feeling that he was being dragged into the case. Would that be a fair statement?
We're talking Watergate case now. Yes, sir.
All right. With regard to the telephone conversation that was recorded by Mr. Colson in late November of 1972, if I can refer to page 6 of that. And of course you said, I believe in retrospect, you probably feel like that you were being set up with regard to that. And of course Mr. Colson's statements could have been self-serving, but do you have that before you? I believe that was furnished a moment ago. Page 6. State that the sixth set of sentences down, Mr. Colson states, I'll leave out some of the language here, said, "If I had ever known it was coming, I would have said to you as a friend, don't get involved. I mean, if you and if we had a conversation like that, I would have said, my God, but the point I've made is that you're smart, among other qualities. You are a brilliant operator, and brilliant operators just don't get into this kind of thing. And this is why I don't want to know any different. This is why I was asked by the Bureau, what about Hunt? And I could honestly say, look, I've known this guy a long time, and he's a smart fellow, and for the life of me, I can't conceive that he'd ever get himself into this kind of a situation. So I want to be able to say that, stay in that position. That's why I don't want you to tell me anything beyond that. Give my love to Dorothy, will you?" And you respond, "All right, I will." Of course, here, Mr. Hunt, he not only presumably be denying any knowledge about any such operations or plans himself, but is denying knowledge of your participation in such plans. Why did you not respond at that time and refer back to some of your previous conversations you'd had with Mr. Colson if he knew about it and the plan, the Gemstone plan, and he knew of your participation in the Gemstone plan?
I believe that our conversation was focused on Watergate, on the Watergate entry that failed.
So your testimony is, as far as you know, although he was aware of the overall Gemstone plan, he was not aware of the Watergate break-in?
Yes, sir.
All right. Mr. Chairman, I have no further questions.
Now, the plumbers had, who were members of the plumbers?
The unit was directed by Mr. Egil Krogh, Jr. His deputy was Mr. David Young. Mr. G. Gordon Liddy was a full-time member of the unit. The stenographer typist was Miss Kathleen Chenow, C-H-E-N-O-W, and I was a part-time consultant.
Now, did the plumbers have a secretary named Mrs. Janelle? Janelle.
I'm not aware of one by that name, no, sir.
Chenow, C-H-E-N-O-W.
Yes, sir. I just gave her name, Miss Kathleen Chenow, C-H-E-N-O-W.
Now, the telephone that the plumbers used was listed in her name in her home in Alexandria, wasn't it?
So I understand.
And yet it was in the offices which the plumbers occupied in the executive office building.
Yes, sir.
That's where the phone was, but it was listed over in Alexandria. Now, why was that?
That was the inadequate response by the communications unit at the White House to my request for a sterile telephone.
A sterile telephone is one that can't be found very readily or traced, isn't it?
Can't be found at all.
Yeah. And so you use that telephone to have conversation, long-distance calls, receive long-distance calls and make long-distance calls to Bernard Barker, didn't you?
Among others, yes, Senator.
How long had you known Bernard Barker?
Since 1959 or 60.
And you made the arrangements with Bernard Barker and Martinez and Sturgis and Gonzalez to participate in the entry of the Watergate, didn't you?
To be precise, Mr. Chairman, I made arrangements with Mr. Barker. Mr. Barker made subsequent arrangements for the other gentlemen.
Now, we have evidence before this committee to the effect that before Miami residents had in their possession, either in their pockets or in their hotel rooms in the Watergate, $53 $100 bills at the time they were apprehended in the Watergate. Do you know where that money came from?
Yes, sir.
Where did it come from?
From Mr. Gordon Liddy.
You know how it happened. We have testimony here also to the effect that this money was part of a deposit which was temporarily made in Mr. Barker's bank account, or his firm's bank account in Miami, Florida, consisting of 4 Mexican checks totaling $89,000 and what is called a Ellsberg check of $25,000. Do you know how that money happened to be deposited in Mr. Barker's bank account, or his firm's bank account in Miami?
In this way, Mr. Chairman, that Mr. Barker was performing a service for Mr. Liddy in negotiating the checks. That is to say, passing them through his bank account and delivering the proceeds to Mr. Liddy.
How long had Mr. Liddy known Mr. Barker, to your knowledge?
Since December 71, January 72.
You,
No, I beg your pardon. I would have to go back to the Ellsberg entry. He knew them from the summer months of 1971.
Now, you worked under Mr. Colson in the White House, didn't you?
Yes, sir.
And when you were operating with the plumbers there, you made reports to Mr. Colson, didn't you, of what you're doing, what you recommended?
Occasionally, yes, sir.
Well, I have in my hand here what purports to be a copy of a report from you to Charles Colson dated July the 28th, 1971, in which you recommend to him. Well, I'll hand this to the witness and let him. you have a copy of that?
Yes, we have a copy of that July 28th memo.
Can you identify that as being a copy of a report you made to Mr. Colson?
Yes, Mr. Chairman.
And in that report, you recommend, among other things, that to Mr. Colson that they should obtain Ellsberg's files from his psychiatric analyst. Did you not?
Yes, sir.
Among other recommendations. And you knew that there was no way in which you could obtain that report except by a surreptitious entry, didn't you? Otherwise, you knew it was privileged under the law of California.
Senator, I was not limiting my options at that point simply to a surreptitious entry. What I had described here was a desirable product. The means of obtaining it had not yet clarified themselves and were not to for, in fact, a month.
Well, you thought that it was desirable to get his files from his psychiatric analyst in order that the CIA might use them to carry out your second recommendation in that letter to perform a covert psychological assessment or evaluation of Ellsberg.
Yes, sir.
Yes. And the objective of the surreptitious entry into the office of Dr. Fielding, Ellsberg's psychiatrist, was for the purpose of getting the records of his records concerning Ellsberg.
Photographing them, yes, sir.
Photographing. Let the records show that this letter of July the 28th, 1971, identified witnesses received as an exhibit, received in evidence as exhibit and be appropriately marked. Now, you have a copy of our memorandum from Bud Krog, is Bud Krog that a nickname for Eagle Krog?
Yes, sir.
From Bud Krog and David Young to Charles Colson, in which they also join your recommendation for a complete psychological assessment and evaluation of Ellsberg by CIA.
Under what date, Mr. Chairman?
August the 3rd, 1971.
I have such a memorandum.
And so Mr. Colson didn't know about the operations being carried on by the plumbers, didn't he? Back in July and August 1971.
I would not, on the basis of this memorandum alone, Mr. Chairman, want to presume that Mr. Colson had comprehensive knowledge of everything the plumbers were either doing or contemplating as of that date.
But he did know as early as July that you thought that they ought to have the files, obtain the files of Ellsberg's psychiatrist, Dr. Fielding.
Obtain access to them.
Did you ever talk to Colson about that matter?
I recall no further conversation with Mr. Colson other than the memorandum of suggestion to him, which was responsive to a suggestion which he made to me.
Now, did you make a report to John Ehrlichman about the surreptitious entry into the psychiatrist's office?
No, sir.
He testified before this committee that after it was done that you made a...
Mr. Chairman, if I may clarify.
I wish you would.
Following the surreptitious entry into Dr. Fielding's office, Mr. Liddy and I compiled a very brief report, which we presented to Messrs. Young and Krog. And whether it went to Mr. Ehrlichman is another matter.
Yeah. You don't know about that.
I have no personal knowledge of that.
Now, you spoke about... You spoke about Mr. Bittman telling you that he had received a telephonic communication which was followed by the deposit of $75,000 in an envelope for you, I believe in his home, Did he tell you who he received the telephone call from?
Are we referring to Mr. Bittman, sir?
Yes.
No, he did not.
And you have any knowledge of the source of that $75,000?
No, sir.
I understood you to state that you had been promised on about June the 21st, 1972, that you would have money furnished you for your sport and also for counsel fees, that you were given assurances to that effect at that time. Is that correct?
Yes, sir.
Who gave you those assurances?
Mr. Gordon Liddy.
My 10 minutes is up, so I will.
Mr. Chairman, thank you very much. I am sure I can finish the line of questioning I have in mind in about 10 minutes, and then we'll be able to proceed to finish possibly this afternoon's inquiry at a fairly early date. I understand that's the wish of counsel and of the witness. Mr. Hunt, you've already testified about how you were employed as a White House consultant, and I won't extend our conversation about that much further, except to say you were employed first by Mr. Colson. I believe you and Mr. Colson had been associated in the, or had been together in the Alumni Association of Brown University. You were both alumni of Brown.
Yes, sir.
And that Mr. Colson was aware of your previous history and background with the Central Intelligence Agency and its predecessor.
Yes, sir.
Would you briefly tell us of your CIA and intelligence background, or if you want me to, I can briefly read the resume that staff has supplied me and you can correct it. Would it be more convenient to do it that way?
I prefer that you do it, sir.
The information we have is that you graduated from Brown in 1940 and entered the Navy. You were discharged after being injured in an accident at sea. In 1942-43, you were an editor for the March of Time and a war correspondent for Life magazine. And from 1943 to 1946, you worked with the Office of Strategic Services, using the Army Air Force as a cover. You trained people in clandestine intelligence work in Orlando, Florida. And then you were assigned to work with Chinese guerrilla bands behind the Japanese lines. You were based for a while in Kunming in southern China, and your OSS unit won a presidential citation. In 1946, you obtained a Guggenheim Fellowship and spent a year in Mexico learning Spanish, and writing. And for 2 years, you were a movie scriptwriter. The CIA was created in 1947, and in early 1949, you joined that agency. After a short period at Washington headquarters, you were sent to Paris as an attaché at the American Embassy. During 1949 and 1950, you were in Vienna, Austria from 1950 to 1953. You were in Mexico City, and from 1953 to 1956, your cover position was that of a political advisor to the Defense Department of Latin America, Japan, Spain, and several European countries. During this period, you were actively involved in the overthrow of the Guatemalan regime. From 1957 to 1960, you were CIA station chief in Montevideo, where your cover was first secretary at the American consulate. When the CIA sought to reassign you from that position, there was a good bit of dispute over whether you should or should not, and there are rumors that President Benito Nardone, the president of Uruguay, was asked to intervene on your behalf to keep you stationed there. At any point in this summary, which I repeat as a staff summary, if you have a disagreement, feel free to tell me so. Your cover as a consultant to the Department of Defense from 1960 to 1965. In 1960, you were ordered back to Washington from Uruguay to participate in the preparation for the Cuban invasion. You resigned from the Foreign Service in 1960 for the purposes of a more effective cover and moved to Mexico and then to Miami, posing as a writer who suddenly had come into an inheritance. For the next 19 months, your alias was Eduardo. You acted as the CIA's representative to the Cuban Revolutionary Council, the prospective post-Castro group, in whose name the invasion brigade was being trained in Guatemala. You resigned your job when certain disputes arose after the assignment of certain people to the provisional government of Cuba, and went to Miami to serve with the Cuban Council. After the invasion of Cuba failed, you served as personal assistant to CIA Director Allen W. Dulles. Your subsequent activities are not entirely known. In 1963, the American ambassador in Madrid refused to accept you as deputy chief of the local CIA station. However, you were in Madrid on unknown business from 1965 to 1966. According to the information staff supplies, the 1966-1967 edition of Who's Who listed you as a retired government official living in Madrid. You returned to Washington in 1968, purchased a home in Potomac, Maryland, and retired from the CIA on April 30th, 1970. From 1970 to 1971, you were vice president at the Robert R. Mullen Company, where you continued to work until you became a White House consultant in July of 1971, until your dismissal on July 17th, 1972. Is that a fair sketch of your career?
Reasonably fair, yes, sir.
Was Colson aware of this rather extensive intelligence, OSS, Bay of Pigs, and CIA involvement?
Yes, sir.
Did you discuss that as a precondition to your employment?
I discussed it with him over a period of years.
At the time you went to work with Mullins and Company, were you aware of, or is it a fact that Mullins and Company had ever been cooperative with or had any connection with the CIA?
Yes, sir.
Were you aware of that?
Yes, sir.
After you became a consultant at the White House, did you contact the CIA about your new position?
I certainly let former associates know of my new White House connection. Yes, sir.
Who? Did you talk to General Cushman?
General Cushman in a different context, sir.
Had you served with General Cushman in the OSS or the CIA in Europe? Had you ever, for instance, shared an office with him?
I had back in the 50s at CIA headquarters in Washington.
Did you talk on a number of occasions to CIA officials about your duties and responsibilities at the White House during your tenure as a consultant there?
No, sir.
On more than one occasion?
Yes, sir.
On how many occasions?
Well, including medical staff people, I would say half a dozen.
Could you name them?
I said half a dozen occasions.
All right. Could you name the people that you talked to?
Well, Dr. Bernard Malloy of the medical office.
Was that in conjunction with the Ellsberg profile?
Yes, sir.
Go ahead, sir.
I may have spoken in that same connection with Mr. Howard Osborne, the Director of Security.
What was that in connection with?
Also the Ellsberg profile. I spoke with Mr. John Caswell in connection with a refreshment of my memory concerning a French leak scandal that seemed to me to parallel the Ellsberg affair. I spoke with Director Helm's secretary about my position.
What was that about?
Simply notifying her, asking her to pass along to Mr. Helms the fact that I now held a consultancy at the White House.
What support did you receive from the CIA? Let me ask you this to begin with. Did you ever seek or were you ever given or have access to the CIA personnel records for the sake of recruiting for your assignment at the White House?
Not in so broad a sense, Senator. I had asked the Outplacement Service to provide me with the resumes of retirees who possess certain limited qualifications.
What were those qualifications?
They had to do with photography and surreptitious entry.
Did the agency from their personnel office supply you with that information?
With some information, yes, sir.
Did you use that as a basis for recruiting?
As a basis for attempted recruiting, yes, sir.
But it was used for the purpose it was sought for, that is, to
Yes, sir.
identify people who might be useful to your assignment at the White
Exactly.
House. Did they also supply you with logistical support, with wigs, with false identification papers, with cameras, with tape recorders, with photographic devices, with photographic processing and printing? Were those things all supplied to you by the agency?
Yes, sir.
Did anyone ever protest that the agency ought not to be involved in this?
Not within my hearing.
Did you ever discuss it with General Cushman or with Director Helms?
No, sir.
None of those support facilities?
I'm sorry. I drew a false inference from your prior question.
All right, well, let me break it into two parts. Did you ever discuss with Director Helms your request for personnel information or logistical and technical support?
No, sir.
Ever?
Never.
Or with his secretary?
No, sir.
Did you ever discuss it with General Cushman?
Yes, sir.
Why didn't you discuss it with Helms? He was the director.
I was directed to General Cushman.
You were what?
I was directed to consult with General Cushman.
By whom?
This requires a little bit of telling, Senator Baker.
A little what, sir?
I'm sorry, Senator. This requires a little bit of telling, of explanation.
Oh, I see. All right. Great. How much telling? How much time do I have left? I've got 3 minutes. Why don't we save that? I've got a few other things I'd like to get to. There was a tape made of your conversation with General Cushman on one occasion, and we've had a transcript of it. Have you seen that transcript?
I have, sir.
You'll notice, I'm sure, from a reading of it, that there are substantial portions of the transcript which are incomplete, some of them assigned to interference from aircraft noise. Can you help supply some of those omissions? Can you tell us what you talked about?
No, sir.
Why can't you?
I'm unable to.
Unable to because you don't know, or unable to for some other reason?
No, sir. Unable to because I don't know.
And have no recollection?
And have no recollection thereof.
You don't recall who told you to see Cushman instead of Helms?
I received a call from General Cushman's personnel assistant or his principal administrative assistant, Mr. Carl Wagner, on one occasion, shortly after I had had a conversation with Mr. Colson relevant to the acquisition of certain technical material. It was Mr. Wagner who told me that I should meet with General Cushman, and I assume this to be responsive to a call which General Cushman had received from some member of the White House staff.
But you don't know who?
At the time, I did not know. No,
Do you
sir.
know now, sir?
Yes, sir.
Who?
John Ehrlichman.
Can you give us the date and the circumstances of that call?
I don't believe I can, no, sir.
Have you seen the Xerox copies of the photographs taken in Dr. Fielding's office that were supplied for this record?
Taken in his office, sir?
Yes, sir. They're Xerox copies of photographic prints that were taken inside Dr. Fielding's office.
I believe I've only seen Xerox copies of photographs taken externally.
Have you seen any copies of photographs taken inside?
I may have, sir, but I don't recall. I'd be very happy to identify them
All right.
if they could
This
be
is
shown.
this is really what I want to find out. You delivered the photographic film, or someone delivered it for you, to the CIA to be processed and printed. Is that correct?
Yes, sir.
And they did process it and printed it and gave you the prints and the negatives, as I understand.
They certainly gave me the prints. As to the negatives, I'm not sure.
Do you know whether CIA still has copies of those prints or negatives?
I have no idea.
Mr. Hunt, I'm dealing now in language that I'm not totally familiar with, but I'm given to believe they are words of art or phrases of art in the intelligence community. Did you have a letter of instructions or its equivalent? with respect to your general operations in the intelligence field and with the Watergate and fielding situations in particular?
No, sir.
Do you understand what I'm speaking of?
Yes, sir.
A letter of instructions means what in lay terms?
It is a brief.
It's instructions in writing on the general description of the job you're about to undertake.
And an authorization.
And an authorization. Does it also include what to do in case you get caught?
No, sir.
There was conversation by General Cushman, I believe, about certain paraphernalia that was given you that was not used in the Ellsberg situation. And we've had material described, as I've described to you, of driver's license, false identification cards, wigs, tape recorders, cameras, and the like. If they weren't used in Ellsberg, what were they used for?
I believe everything was used with the exception of the tape recorder.
Well, where was the tape recorder used?
Tape recorder was used for the transcription of overt interviews.
Overt interviews of whom?
In one case with Mr. Clifton DeMott.
Who is that?
He is a government employee, former government employee at least, who is a contact and former employee of Mr. Robert Bennett, my one-time employer.
Do you know anything about the Dahlberg checks and the Mexican money?
May I inquire, sir, if...
Well, let me just ask you a specific question. Do you know whether or not, from your experience with CIA or other operations, Mr. Dahlberg was ever considered as a CIA contact?
I have no knowledge of that, no, sir.
I'm told, Mr. Chairman, that my time's expired. I thank you, Mr.
I bet. There's something on the rest of the committee been requested by the witness and his counsel to recess at this time. And if it's... Before we do, however, I'd like to put in the record the memorandum of August 3rd, 1971, for Charles Colson from Bud Krogan, David DeYoung. That'll be appropriately numbered as exhibit, and the committee will stand in recess till 10 o'clock tomorrow.
Do we have an exec in the morning, Sam? So it was a relatively short day, in Watergate Committee terms at least. As we heard at the beginning, Hunt's physical condition is not the best, and it was clear that he tires easily. Well, Peter Kay spent the day on Capitol Hill with E. Howard Hunt today, and now Peter's back to talk about the mood of these hearings and what happened today, along with Hugh Sidey, who's Washington Bureau Chief of Time Magazine, and Jack Murphy of the Georgetown University Law Center. Peter?
Gentlemen, a lot was at stake at the hearings today, the future course of the committee's work, the possibility of future network coverage, and not least of all, the public acceptance of the need for future hearings. And all of this rested on the first witness, on E. Howard Hunt. And there was a feeling where I sat up in the committee room, and I must admit I shared it, that Hunt bombed, that he really let them down, that it was a not too productive and not too interesting day. How did it look from your end, Hugh?
Well, I think you've been infected by that Nixon virus, that is, to turn this down, turn it off. I seem to believe that the American people want this. I admit, quite honestly, that some people persist in this idea that the hearing should be stopped, television turned off. There are a few polls that suggest this, but by and large, the preponderance of scientific evidence, the polls show quite the opposite. The networks show higher listenership for the hearings. Your network here shows higher listenership. I think they still want them. Quite honestly, I think another factor enters this. I suspect maybe Washington has grown more bored with the hearings than the people out there, and that's perhaps what happened with Mr. Hunt. He wasn't as explosive as we're used to around here, but I think it was highly significant, deeply moving from a human standpoint, and rather fascinating in detail.
Well, as far as the Nixon virus, you're closer to the man than I am, so I suspect that if you've avoided the virus, maybe the rest of us have too. But seriously, even Sam Dash, if you remember the testimony during the morning session, how disjointed it seemed to be, and the fact that when they went over and over again, did Colson really know or didn't he know? And nothing ever seemed to get pinned down. And finally, we talked to Dash during the luncheon break, and he admitted that Hunt was a sick man, a broken man, and that he just really hadn't panned out in public session as they hoped he had in executive session. And since they could bring back anybody they wanted to for the lead-off witness, it seems to me that they got something of a dud.
Well, excuse me.
Go ahead.
I was going to say, from a lawyer's point of view, I was relatively bored with the proceedings today. This is a slightly different attack than you two are discussing. Not a question of the public's satisfaction or satiation with the hearings, but rather the manner in which these questions were asked and the answers elicited. It was not sharp. It was not focused. It may very well have been that my dear colleague and kind-hearted friend, Sam Dash, was somewhat conditioned by Hunt's evident weakness and was not coming through as strongly and as firmly as he has with previous witnesses. But had this been a case before a jury, I'm sure that the jurors would have been extremely confused about what was going on.
I would like to interject one thing. First of all, I disagree with you and Peter. In the first place, I don't know who you're comparing E. Howard Hunt with in terms of prior witnesses, and I would like to get to the substance of what was said today, regardless of who was bored or who wasn't bored. Hugh, how would you characterize what was said today by E. Howard Hunt in terms of filling in some cracks here and there?
Well, just one comment. First, I agree. Let's not cast it in terms of show business. I think that's an insult to the American public. I think it's gone far deeper now. They've spent several weeks contemplating this thing. I think their perception of it goes beyond what we understand.
That's the point I was going to make, and you made it much better. It should not be viewed in terms of show business.
That's right, and I think that in terms of that, I found this fascinating. I found Howard Hunt's personal story to be at one of the crux of the tragedies of this whole thing, that here is a man carrying out orders, as he thought, for whatever lapse or whatever reason, from his own government. He stands to spend the rest of his life in jail. He has 4 motherless children, and there isn't, to the best of my knowledge, a statement of remorse from the White House, from these people that put him into this business. I have not detected it from the President. I have not detected it from Magruder, from any of these people, Dean, from Ehrlichman or Haldeman. I find that just appalling. And I think out in the American public, that's one of the things that makes people so uptight about this, or that disturbs them so much, that there is no expression of what was done wrong to these other people. Not only Hunt, but the people were victimized by this, or no expression of remorse about what's happened in the country. They still stand there, say, I didn't do it, let's cover it up, let's go on.
All right. I would agree that the human story of Howard Hunt was an interesting one, but substantively, what did he add to the total of knowledge we have? He did implicate for the first time Charles Colson, and I think we ought to talk about that in a minute. But I think we ought to talk about it in the context of who cares about Charles Colson right now, really? I mean, now we're getting on. We're worrying about Spiro Agnew. We're worrying about a number of other things, the presidential tapes. But what's the drama? You know, to put it in Howard Baker's own words, or to paraphrase him, we can't hold a hearing on how much did Charles Colson know and when did he know it. Who cares?
Well, we're beginning to penetrate, though, little by little, a little deeper, don't you feel? Now, here's a man that has denied all implication up till now. Here's a man described by some as the president's own man. It's just we're penetrating just a little more, aren't we? I have that feeling.
Well, I think that's right. You do have this notion that Colson knew more about this earlier on than we thought. That is some added dimension. On the other hand, you have confirmation of the notion that there was no discussion of clemency between Colson and the lawyer for this man, which confirms the other side, which was saying that this was not an issue ever between these respective parties.
Yeah. I was just going to interject, Jack. What about this long and somewhat hard-to-follow argument on the attorney-client relationship? I know I got lost in it. Maybe as an attorney you can clear it up.
Well, I think it was confusing. Usually the rule is that if you have, in effect, waived your privilege with respect to any portion of general information, you waive it as to all. If you consent to its disclosure, either by yourself, of course, or through your attorney or someone else, you waive it as to all relevant information. This is, I can read you a rule about it. A person who would otherwise have a privilege to refuse to disclose or to prevent another from disclosing a specified matter has no such privilege with respect to that matter if the judge finds that he, without coercion and with knowledge of his privilege, made disclosure of any part of the matter. Now that, I think, is the critical question, without coercion. The suggestion today was that because of the outstanding provisional sentence of Judge Sirica, coupled with Judge Sirica's injunction that Mr. Hunt ought to cooperate, Mr. Hunt is taking the position, I think, through his attorneys, that he is being coerced into speaking contrary to the right he has under his privilege. And that should sometime arise later when the question is, does Mr. Bittman have to speak about the matters with respect to which Hunt has now testified? Bittman may have to take the position that the coercion involved in Sirica's order invoked this exception to the rule about waiver. I don't know that I've made that any clearer, but it's an unusual proposition legally. And normally what Hunt had said today would have waived the privilege for him and opened up. But I think there may be a backstop position, and that was what Mr. Sachs was talking about.
Let me ask you a much simpler legal question. Mr. Hunt testified that he paid Mr. Bittman $156,000 in legal fees. That's an awful lot of money to plead a client guilty. Have legal rates become that inflated?
I think that's a good point. The inflation has really caught up with the legal profession or the clientele of the legal profession. I can't really comment on the practice of another colleague in the bar. I will say euphemistically, I thought it was an extraordinary figure.
Hugh, or Jack, or Jim, or anybody, but we saw, I think, more partisanship in the first hour this morning with everybody except Senator Weicker on the Republican side, Fred Thompson, Senator Gurney, Senator Baker, all of them chipping and snarling a little bit at some of Sam Dash's questionings and some of the procedure. Do you think that's going to be the pattern now?
Oh, probably. I think, these things change in nature as they go along. There isn't any question of that. And I suppose it'll be cast in more partisan tones. Indeed, there's part of this offensive that we talked about earlier to try to picture it as that, But once again, in this nation of ours, not as some would have it, you don't have to listen to these hearings. The American public can get up with a minimum amount of effort, walk over, and with very slight further effort, turn the television knob and turn the hearings off.
Perish the thought.
They don't have to read about them in the morning, all of this thing. So, this argument, indeed, that we have about what's involved here and the partisan charges and what should be broadcast seems to me, is we can leave it to those who want to see it, and those that don't can walk away from it.
Gentlemen, thank you both very much. Jim?
Okay, you've heard what the four of us think about today, E. Howard Hunt's first day, and now you can take that any way you want to and form your own opinions and draw your own conclusions. We will be back tomorrow night for the committee's 39th day and E. Howard Hunt's second. Until then, for Peter Kay and Impact, I'm Jim Lara. Thank you and good night.
From Washington, you've been watching gavel-to-gavel videotape coverage of the hearings by the Senate Select Committee on Presidential Campaign Activities. This program was made possible by grants from the Corporation for Public Broadcasting and the Ford Foundation. This has been a production of NPACT, a division of the Greater Washington Educational Telecommunications Association.